With the consent of other side, I would like to mention item number 34.
34.
34, Lordship.
Yes. What is your prayer?
Let it come after 1 week, Lordship. I have taken consent from Mr. Mannan.
Heard Miss R.D. Majumdar, Learned Counsel for respondent number 6 and 7, who prays for an adjournment on the ground of personal difficulty. She submits that she has informed Mr. Y.S. Mannan, Learned Counsel for the appellant regarding her prayer for adjournment, who has no objection to the same. Hence, prayer is allowed.
Lordship,
Let this matter be listed
on any date, Lordship.
13th of February.
Lordship, I need one more prayer, Lordship. Item number 54. Lordship, in the end of the day, it might not reach for that matter, Lordship. It is just listed for the first time and notice has to go to the respondents. Delay is of 92 days, Lordship. So, Lordship, if the order can be passed now.
Okay, we'll issue notice.
Yes, just notice. This is
Okay.
first.
We'll take up the matter and issue notice. 54.
As first
No,
item.
not at.
Acha.
We'll take up it, the matter. You need not to be present. We'll issue notice.
Okay. Highly obliged, Lordship.
54, no?
54. 54.
Okay.
Highly obliged.
May I please, Lordship? I have filed an IA application for early hearing in RSM. So the matter may be listed on Wednesday.
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 Okay.
May I please also? So I beg to mention for listing on IA in MEC appeal for withdrawal of 50% deposit amount, Lordship, and I
When
file
do you want?
next week, Lordship, 27 or 28.
27.
Much obliged. May I please, your Lordship? With due consent of other side, I beg to mention item number 30. The leading counsel of this instant case, A. Vishwas, is having some personal difficulties.
What is your name?
A. Banerjee.
A.
Banerjee.
I am appearing for the respondent.
You have any objection? Heard Mr. A. Banerjee, item number 30. Who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant / applicant. Also heard Mr. B.D. Deka, A. Deka, Learned Counsel for the respondent who does not oppose the prayer. Hence the prayer is allowed. Let this matter be listed 12th of February.
Obliged.
May it please your lordship. Lordship, I beg to mention a listing of an IA, lordship. For orders, lordship. It
When?
will, Wednesday, lordship.
Okay.
Much obliged.
May I please, your Lordship? Lordship, I beg to mention a transfer petition for listing on
When?
2nd of Feb.
Okay.
Obliged.
May I please, your lordship, I beg to mention for listing 2 regular first appeal, lordship. Witness the lordship,
At-
fresh matter, lordship, most
Okay.
deeply obliged.
When have you filed?
Lordship, 5/1/2026. And another is 17/1/2026.
17 would be listed in its due course. Why mentioning? First one is allowed, second one will come up in its due course.
Deeply obliged.
May I pray? May I pray for listing of an IA tomorrow, lordship? A connected appeal has also been listed as item number 16 and in court number 14.
Okay.
Deeply.
May I please, your lordship? My lord, I beg to mention item number 27 of today's system. I have
Yes.
taken consent from the other side as well. The matter may be taken in the first or second week.
What is your name?
G.U. Ahmed.
Heard Mr. G.U. Ahmed, Learned Counsel for the applicant / appellant who prays for an adjournment on the ground of personal difficulty. He submits that he has informed the Learned Counsel for the respondent side who has no objection to the said prayer. Hence the prayer is allowed. Let this matter be listed 11th of February.
May I please, your Lordship? With the consent of the other side, I beg to mention item number 35, Lordship. Lordship, conducting counsel, Mr. A.R. Shah with some personal difficulty, Lordship.
What is your name?
R. Dev, Lordship.
Heard R. Deb, Learned.
Lordship, interim order will be continued till the
Are they Learned Counsel for the respondent who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. Also at Mr.
as they behalf of the.
as they learned counsel for the applicant slash appellant who has no objection to the prayer. Hence the prayer is allowed. Let this matter be
After this,
listed
sir,
on 12th February. On 12th February,
obliged,
the interim order shall continue till next day.
May I please, Your Lordship, I beg to, for listing of an RFA, Your Lordship, for the first time, I filed in on 28/8/2025, Your Lordship.
Okay,
Tomorrow,
when?
tomorrow, Lordship.
Okay.
Obliged.
Please, Your Lordship, I'd like to mention item number 44. I've taken the consent of the other side, Your Honor.
Lordship, I
Oh.
am for the caveat, or Lordship.
What is your prayer?
Adjournment for a week, Your Honor.
You have any objection?
Connected.
45. You have any objection? Heard, Miss, what is your name? M. Sahul, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty. Also, heard Mr.
DK Bora.
D.K. Boral, learned counsel appearing for the caveator who raises no objection to the said prayer. Hence, the prayer is allowed. Let the matter be listed. 12th February, March. 12th of March.
Highly obliged, Lordship.
Also, I beg to mention item number 51 of supplementary list, Lordship. Also, I filed an affidavit in support of justice service, Lordship. That may be checked with the record, Lordship.
Bring that. Okay.
May I please, Your Lordship? I would like to mention item number 11 of the daily list. Actually, matter may kindly be listed day after tomorrow, Lordship.
Why?
There's some personal difficulty on account of the advocate law.
Then you cannot choose the date. Who is for the other side? Heard, Mr. What is your name?
A. Ahmed, Lordship.
Heard, Mr. A. Ahmed, learned counsel for the appellant who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed on 11th of February.
Obliged.
May I please, Your Lordship, Your Lordship, I beg to mention item number 3, Your Lordship, as the conducting counsel, namely R. Rafa, is due to his ill health could not appear before this court, Your Lordship. His name is not reflected in the pause list, Your Lordship.
Heard, Mr. What is your
I
name?
am Kashyap, Your Lordship.
Heard, Mr. M. Kashyap, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of conducting counsel for the petitioner, Mr. R. Rabha. The prayer is allowed. Let this matter be listed on 4th of February.
Obliged.
May please, Lordship. Lordship, I beg to mention item number 48 of supplementary, my lord. My lord, my son is now out of station for his medical treatment, my lord. So, my lord, matter will be picked up.
What is your name?
RIVM.
You have informed the other side.
Oh, my lord. Yes, sir.
Fresh matter.
Yes, my lord.
It is in orders column. Item number 48.
Wrongly listed in orders, my lord.
Okay, okay. Heard, Mr. What is your name? Heard,
R.I.
Mr. R.I. Bhuai, learned counsel for the appellant who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. The prayer is allowed. Let this matter be listed on 9th of February.
Obligement. May it please, your lordship. My lord, I beg to mention listing of 3 MSs in the 3rd week of February, my lord.
For what?
For hearing, my lord. It's a
No,
old matter, 2013 matter, my lord.
Hearing, it has to come to orders column first.
Can it be taken up in orders column? It can, because the matter is fixed for hearing at this stage, these 3 matters.
Date Tadya. No, orders column. 10th of February.
I'm obliged.
May please, your lordship. Lordship, I'm praying for listing of an IA. And this IA was for Lord for condonation of delay in filing the connected CRP. And it was last listed on 24/9.
When you want.
Any day next week, any day, 27, 28, any day.
Yes. 27th.
Lordship, I beg to mention for listing of IA of condonation petition, Lordship, in connected LA appeal.
First
Lordship-
week of February.
Lordship, Lordship, in one connected matter is fixed on 21st.
I'm praying for this matter may be fixed on 21st.
Okay, on 21st.
21st of the January. Obliged. Wait, with the lordship. Your lordship had the CRP 83 of the 25 last, before vacation. So, in the case lordship, I have something to submit. So I want to submit a list of dates in the matter to clarify all the things. If your lordship-
Who is on the other side, Mr. Rubul Ali?
Yes, Lord.
You inform him.
Lordship, I shall inform him and I shall give a copy to him also before filing.
No, before mentioning, you have to inform him.
Okay, Lordship. Then I shall make a mention tomorrow, Lordship.
You can mention at 2 also, if you, or tomorrow.
Tomorrow, Lordship.
Okay.
Obliged. May please, Lordship. Back to mention for listing of an RSA for orders. Lord. There is some urgency, by the way. On 21st now. It is fixed in the execution code for appearance on 21st.
Okay. Okay.
Obliged.
May I please your lordship? I beg to mention item number 46 for admission in supplementary list. Lordship, I am on behalf of Mr. Fukan for the petitioner. Lordship, 46. Lordship, Mr. Fukan will be unable to appear today because of a bereavement in his immediate family. Lordship may give any other date for this matter.
My lord, I am appearing for the respondent, for the petitioner, my lord.
You have any objection?
No, I don't have. After 18th of February, it will be.
Okay. What is your name?
He does.
Heard Ms. D. Das, Learned Counsel for appearing on behalf of Mr. R.B. Fukan, Learned Counsel for the respondent. Praise for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. Also, Mr. D. Sharma,
P. Goswami.
P. Goswami, Learned Counsel for the petitioner who does not objects to the prayer. The prayer is allowed. 27th February.
Much obliged.
May please, your lordship. Lordship, I beg to mention one FAO, lordship, where I am appearing as respondent, lordship. In this case, injunction was granted in our favor, directing us to do our business in the pre-clean industry. That was stayed by the Honorable High Court, lordship. After staying, so they are disturbing in the
What is the prayer?
tomorrow or day after tomorrow, lordship.
Day after tomorrow.
Lordship obliged. And one another RFA, lordship, in order columns, any date, tomorrow, day after tomorrow. Notice issued long back, lordship, in the month of October
RFA
for orders
27.
obliged.
May I please your lordship? Your lordship, I beg to mention one RSA and one IAC. The IA is for condemnation and the RSA is for on hearing column,
Same case.
lordship. Two different cases.
RSA would first be listed in orders column. 29 January. Same 29 January.
Bless.
May I please your lordship? I beg to mention for listing of two MSc appeal lordship. Both were referred to mediation, but both were not resolved lordship.
In orders column.
So you kindly listed on 22nd January.
27th.
Rural Junior is present in this board.
Okay, okay. When you will be filing?
Day after tomorrow, Lord.
Okay, allow. Give a copy to
I
others.
shall give an advance copy to them. If they want to file, they can file also. Counter.
Okay.
Right.
Delivery of order 29th of EDS assignment.
Item number 1. Charge sheet and matter. PCR may be called. No, so there has to be some download.
What is the matter?
Your lordship, earlier.
22C. On what ground you are seeking?
Earlier, your lordship rejected this matter. Now, when still date, no evidence is taken. 1.5 years almost, felt with conflict.
Not complete. He was arrested on lordship 5/12/24.
How much time has
5
lapsed?
24, and in this case, my lord,
Now, how much time has lapsed? For how long you are behind the bars?
I am, my lord, today is 1 year, 1 month. 1 year, 2 months.
We cannot keep it
No, my lord,
pending for next 4 months.
my lord, this is a matter is this ground, my lord. Earlier, your lordship has rejected at that stage, my lord, and nothing recovered from me, my lord. It is also on one of the ground. Nothing recovered from me, my lord. Let the, my lord, TCR may be called for.
No,
Whether
if nothing is recovered, we can decide it now.
nothing recovered earlier.
Where is the rejection order?
Earlier rejection order, my lord. Page 60,
Page?
60.
Lordship, the first schedule the second rejection order, page 55.
Why it was rejected?
My lord, on that date, my lord, two persons were, the two accused persons bail petition were heard, my lord, on 3/3/2025. And the prime accused was granted bail on that date, my lord. Taking the ground of that, the evidence was not taken. At that date, my lord, 1.5 years have been elapsed. But thereafter, my lord, I was arrested on 5/12/2024. On that date, my lord, kindly see the co-accused order, my lord. Kindly see.
No, no. On what ground you are seeking bail?
My lord.
First, let us be clear
My lord,
that nothing was seized from your possession. That is your ground.
this is one of the ground. And from the.
What is the second ground? Other
second
ground?
my lord, since the time, it is almost 2.5 years have been elapsed, my lord. Till date, no evidence is taken.
How long
But
you are
I
behind
am
the bar?
in custody since 1 year, 5/12/2024. Because since nothing was recovered, I was absconding, and I was arrested on execution of NBWA. So it was recovered from Jainal Hoque, who was granted bail on 3/3/2025.
No, he was granted bail on some other ground.
He was granted bail on the ground that the evidence was not taken on delay ground.
Prolonged incarceration. You cannot take advantage of that ground. As on today. For that, you have to wait for another 4 months. And we cannot keep this bail application pending for 4 months. If you have any other ground, you can submit.
Another ground, my lord, is there. Kindly see the, my lord. Page 8, para 10, man. Para 10, 11, 12.
Yes, what is the ground?
That the petitioner begs to state that the seizure list prepared in that case at the time of recovery of the seized contraband, the name of the owner of the house has been shown as one Azaduddin of Sunapara under Badalpur police station. However, on
Whether these grounds were considered earlier or not.
It's 58.
even page 11, para 11 also, my lord. Para 11 is also ground, my.
What is that ground?
In that case, my lord, that since there was an dispute between the husband and wife, my lord. So I was driving out from my native home.
Whether this ground was considered earlier.
Considered.
This was also considered.
Considered by an additional affidavit, my. That was not on the ground in the main pleadings, my lord.
But
I've
whether
taken
it
that-
was considered or not.
Not considered, my.
Not considered.
I can show from the record.
Then
Your lordship, but that was that ground was not considered by your lordship, my. It was rejected, saying that that ground was not taken earlier on the first petition. So it was rejected.
okay, make your submissions. You cannot pray for calling of the TCR. That is for the court. If court feels it necessary to consider, you can plead your case that on so and so ground you are seeking bail. If necessary, we may call for case records or we may dispose of this.
I submit the present status of the trial, my, on next date, my.
No,
Any date, my lord.
you cannot take that liberty. You plead it today, otherwise I am going to dispose it off. You may take your time. We will take it off after some time. But you have to, by filing a case in the court and appearing before the court, you have to be ready. You cannot,
My lord, this is the ground, these are the ground, my lord, what I have, my lord, submitted in this pleadings, my lord, that one of the ground is, that was also rejected in earlier stage. This ground also, my lord, earlier, on the first petition, it was rejected. Subsequent petition, my lord, that I, by way of additional affidavit, that ground was taken, which was also rejected by your lordship, because that ground was not taken in the first petition, only on this
yes,
ground.
yes, Mr.
Lordship, whatever ground he has taken, Lordship, I will give point to point reply. Lordship will kindly see the first rejection order. Lordship will kindly come to page 58.
Yes,
58 Lordship, para 11 Lordship will see. At that time also this submission was made. Lordship, he earlier filed an AB, which was rejected. Thereafter, non-bailable warrant was issued and he was arrested. For that action, Lordship, there was a delay of around 1.5 years in framing the charge. That is reflected in paragraph number 11. Next, Lordship will see paragraph number 14. Lordship is paragraph number 14.
yes,
So 14, Lordship will see, learned counsel for the petitioner has been able to show some discrepancy in the materials on record regarding the ownership of the rented premises. However, it appears from the materials that at this stage there are sufficient materials to indicate that the rented premises was of the present petitioner, and though the signature of his wife were not obtained on the seizure list. However, the eyewitness have deposed that she was present there at the time of recovery of the seized contraband. The name of the owner of the premises from where the seizure was made is shown as Azaduddin in the seizure list, whereas the witnesses who have been examined under 161 have named the owner as Angur Bibi. Be that as it may, the question at this stage is not as to who is the owner of the rented premises, but as to who was residing and using the rented premises at the time when the seizure of the contraband was made, and there are sufficient material to show that the premises from where the seizure was made was being used for residing by the petitioner and his wife. So it was rejected. But important thing is, Lordship, in this order, Lordship, in that bail application, he did not take the plea that he was not residing with the wife. Thereafter, Lordship, subsequently, by the time the second bail application was filed, in page 60, he took the plea by filing an affidavit, Lordship, that he has not been residing there since 1 year due to some matrimonial dispute. And that, Lordship, will find observation at para 6 at page 62. Before that, Lordship, para 6, Lordship, may kindly see. Again, he took the plea of search and seizure, Lordship, which was also rejected by your Lordship at paragraph number 6. Sought some time to produce some authority in support of a submission that search of the premises from the contraband was recovered was not in pursuant to the law enforced. Where, however, when the matter was heard, the said plea was not praised by the so-and-so. Now, paragraph 7, Lordship. Petitioner has submitted that the wife of the petitioner has filed an additional affidavit inter alia stating that the petitioner no longer stays with his wife and he left her company about 1 year prior to lodging of the FIR. It is also stated in the affidavit filed by the wife of the petitioner that the petitioner during his period staying at Mizoram, and it is only when he came to know about the pendency of a non-bailable warrant of arrest, he came back to Karimganj, where he was arrested in execution of non-bailable warrant so-and-so. Now, Lordship will see next paragraph. The learned counsel for the petitioner submits that when the petitioner was not staying in the residence from when the contraband was recovered, there is no reason. Same ground, Lordship. Paragraph 10, Lordship, I'm sorry, paragraph number 12, Lordship will see. It appears that in none of the earlier occasions, the petitioner had disclosed the fact narrated by his wife in the additional affidavit filed today. This court is of the considered opinion that if the said facts are regarded as relevant facts, the petitioner would be at fault of suppressing the material facts from this court on earlier occasions when he approached this court for seeking bail. It has already observed by this court that while rejecting the prayer for bail on earlier occasion, there are sufficient materials in the record to indicate the premises from where the seizure was made was used for residing by the petitioner and his wife, and therefore the contents of the additional affidavit filed by the wife of the petitioner for the second time does not imply So Lordship, all those grounds have been gone into detail by your Lordship. He has no new grounds, Lordship. Simply staying, Lordship.
Subsequently, my lord, trial was not progressed, my. Subsequent of the earlier order. Trial is not progressed. Same position trial is.
So trial is not progressing. So you are praying for bail on the ground of prolonged incarceration.
Because
Is
my
it
lord-
not?
Because my lord, the case was since 2023. Case is since 2023 and
You are one year, 1 month behind the
1
bar.
year, almost 2 months.
Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 183 of BNSS, under section 483 of BNSS has been filed by the petitioner, namely Jamal Hussain, who has been detained behind the bars for since 5/12/2024 within bracket for more than 1 year, 1 month in connection with special NDPS case number 109/2023 pending in the Court of Sessions, learned Session Judge Karimganj, corresponding to Karimganj PS case number 672/2023 under section 22C/29 of the NDPS Act. It is pertinent to mention herein that before the instant bail application, the petitioner had approached this court on earlier 2 occasions, and on both occasions, the prayer for bail was rejected by this court, citing various reasons. Learned counsel for the petition. No. The gist of accusation in this case is Code Para 3 from page 48, Para 4 from page 48. Learned counsel for the petitioner has submitted that the contraband was seized from the rented house where the wife of the petitioner was residing. However, he was not residing with his wife at the time of the seizure. He further submits that since the last rejection of bail order by this court on 3/3, which is the last rejection order?
16/9/2025.
3/9/2025.
16/9.
16/9/2025, there has been no progress of the trial. He further submits that in the meanwhile, the prime accused, namely, who has been granted bail?
Journal of 3/3/2025.
Namely, Joinal Haq, has already been granted bail by this court on 3/3/2025. As such, learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars for more than 1 year, 1 month, and trial has not progressed since the date of last rejection of his bail application. Hence, he may be granted bail in this case on the ground of prolonged incarceration. He further submits that the petitioner is ready to cooperate in the trial. On the other hand, learned additional public prosecutor has vehemently opposed the prayer for grant of bail to the petitioner at this stage. He submits that in earlier to bail rejection order of the petitioner passed by this court, the grounds taken in the present bail application were duly considered and where the application for bail were rejected on merit, finding sufficient incriminating material against him. He submits that the petitioner has failed to plead any new ground for moving this bail application for the third time. He also submits that the co-accused Joinal Haq was granted bail mainly on the ground of prolonged incarceration, as by the time when he was granted bail, he had completed more than 1 year, 6 months of incarceration, whereas the present petitioner has not even completed 1 year, 2 months of incarceration. He submits that the detention of the petitioner, considering the nature of the offense involved in this case, may not be regarded as long enough to override the embargo of Section 37 of the NDPS Act. I have considered the submissions made by learned counsel for both sides. It appears that the grounds pleaded by the petitioner in the instant bail applications are more or less same grounds which were pleaded by him in his earlier bail applications. And those grounds were considered and rejected, and the prayer for bail was rejected on earlier occasions. It also appears that no new grounds has been pleaded in the instant bail application by the petitioner, apart from the fact that the trial has not progressed since the date of his last rejection of the bail application. Stop. Though this court is of the view that prolonged incarceration overrides the embargo of Section 37 of the NDPS Act 1985. However, for that, the court must come to a finding that the incarceration of the petitioner is long enough to reach such a conclusion. However, in the instant case, as the petition, the petitioner has not even completed 1 year, 2 months of incarceration. And considering the fact that the quantity of contraband seized in this case is of commercial quantity, the period of detention undergone by the petitioner till date, in the considered opinion of this court, cannot be regarded as long enough to give him benefit of bail by overriding the embargo of Section 37 of the NDPS Act. Stop. More so, as the co-accused was granted bail only after completion of 1 year, 6 months of detention behind the bars. For reasons mentioned herein above, this court finds no merit in the instant bail application, and accordingly, same is dismissed.
Lordship, I'm sorry, while dictating Lordship, Lordship had gone to the gist of accusation at page 48, and Lordship has quoted paragraph 3. Lordship, paragraph 4 is also relevant.
Oh,
48.
और question है?
Three and 4.
Yes, 3 and 4. 4 is also read.
Item 16. May I please?
Yes.
All of this petitioner is also in the custody for a 340 days, my lord. And who has been charged under 6 of the POSCO Act. Now, earlier Lordship has rejected his bail application.
Where is the rejection order?
That is Lordship will find page 46. Starts from my 46, my lord. And the relevant paragraph Lordship will find observation paragraph 9. At that stage, my lord, 6 witnesses been examined. Sorry, my lord, 3 witnesses been examined at that stage, my lord.
Yes.
And there are, at that stage, my lord, 3 witnesses who happens to be the students. Their examination, Lordship has felt necessary prior to release the petitioner on bail, my lord. Now, 6 witnesses, including those witnesses, been examined by the trial court, my lord. And thereafter, no further witnesses been examined by the trial court. And
Whether these 3 witnesses, Kalpana, Marian and Sylvester,
yes,
have been examined,
yes, my lord.
whether you approach the trial court after
Yes,
that,
yes, my
seeking
lord.
bail.
I have page 73 is the order of the trial court, my lord.
Yes.
From my lord, 6/11/2025, my lord. No further witnesses been examined. My lord. Last witness is PW6. That is the status of the case right now, my lord.
What is your ground?
Well, that's the prolonged impersonation, my lord. That's the only ground, because I cannot go into the merit of this case, my lord. Merit already been discussed by this honorable court, my lord. And when earlier lordship was rejected, at that time, I was.
No, the trial court has rejected considering the testimony of the witnesses.
Yes.
They
that's
have
true.
implicated you.
Yes, yes. That was earlier also, it is there, my
So
lord.
there is a possibility of conviction in this case.
The possibility may be, my lord, but we don't know right now, my lord. There are other witnesses there. And the medical witnesses goes in my favor, my lord. The medical witnesses, witness, my lord, there's no evidence of recent sexual.
No, why you should be allowed to go on bail now?
Definitely, my lord, the prolonged incarceration and the preparation and because I was his custody. Definitely, my lord, there is a possibility of considering the medical witnesses and the contradiction. There are some contradiction. So there may be a possibility of my acquittal also.
Yes.
And your lordship has already said that in the earlier order, and I can approach because there is no chance of now tampering with the evidence, my lord. Only the official witnesses left out, my lord. Remaining. So another 5 witnesses are yet to be examined.
What was the accusation?
Updated status report. Oh, ignition.
Yes, Mr. Sharma. Anything else? Mr. Bora?
That's all, my lord, because I'm not going into the actual merit, only the medical evidence which comes in my favor. And there's some, if we go by the evidence, and the lordship has come out with an observation that these 2 witnesses are required to be examined prior to consideration of the bail warrant. They have examined all the witnesses, material witnesses, my lord. Now, rest of the witnesses, including the IO, is very vital for me so that I can come out and take a proper defense, my lord, at this stage. My lord.
Yes.
Lordship already has seen 6 witnesses have been examined, Lordship, including the independent minor witnesses also. And
Also, I didn't do.
Yes.
Your Honor, this is a Manish Wood, Your Honor. The respondent herein was the plaintiff who has filed the money suit against the present petitioner for recovery of money, my lord.
You are defending.
I'm the defendant. And
Yes.
During appearance, I have filed a petition which was allowed for time for filing WS. But in the meantime, when the date was fixed for as 7/7/2025, which was inadvertently recorded at 7/8/2025, yeah, by the learned counsel conducting the case, matter. And according the counsel could not appear on the date, and the matter was proceeded ex parte, and he has preferred an petition under Order 9, Rule 7, Your Honor. And the petition was also rejected.
You filed a petition under Order 9, Rule 7.
Rule 7, my lord.
Where is that petition?
In page 34, my lord. Although, my lord,
You have not mentioned the.
mentioned exactly, my lord, the petition it was rejected on the ground that it has not mentioned the provisions as to the filing of the petition, and further the grounds of delay, my lord. My lord, my humble submission is that as this was a inadvertent on the part of the
When is the next date?
tomorrow, my lord. It is for argument, my lord. And that apart,
Argument?
yes, my lord. By the time on 13/8/25, my lord, or 3/1/26, it was fixed for ex parte evidence, and subsequently tomorrow is fixed for the argument, my lord. And that apart,
Why you are, where is the order?
impugn order is that
16/8.
page 37, my lord.
Okay, we'll issue notice.
My lord, that apart, my lord, may take up page 23, my lord. That is the plaintiff filed by the respondent, my lord. Page 23, my lord. In the
Page?
23, my lord.
Yes, what you want to show?
And in the first paragraph, my lord, it is specifically mentioned that the suit is for recovery of amount of so and so, and the plaintiff company has being the value of the made tea received by the defendant for his retail business of sale of made tea with interest so and so, so and so. So, you know, by admittedly, my lord, you know, the suit was for commercial transaction, man. And in view of that, Order 8, Rule 1 may invoke. And in that provision, 150 days.
You have raised this plea before the trial court. Have you raised?
No, my lord. This is statutory provision, my lord may consider, my lord.
No, you should have raised this plea.
Exactly. This is a inadvertent mistake on the part of the council, my lord. And for this, my lord, the petitioner should not suffer, my lord. That is my humble submission.
We are issuing notice. What is her name?
A.K. Sahu, my lord.
Heard Mr. D.
A.K. Sahu.
A.K. Sahu, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, Mrs. Usha Shah, impugning the order dated 16/8/2025, passed in Ms. J case number 278/2025, arising out of money suit number 16/2024 by the Court of Learned Civil Justice Senior Division number 2, Kachar Silchar, whereby the prayer for vacating the ex parte order dated. Where is the impugn order? Wait,
Sorry, my lord.
ex parte order. Passed by the trial court was rejected. Stop. Issue notice to the respondents. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 20th of February.
My lord, tomorrow is the date fixed for argument, my lord.
Stop.
Then
Learned counsel for the petitioner has submitted that the money suit number 16/2024 is fixed tomorrow before the trial court for argument, ex parte argument, and unless an interim stay is granted, he would be highly prejudiced. Considering the submissions made by learned counsel for the petitioner, the further proceeding of money suit number 16/2024 shall remain stayed till next returnable date, list accordingly.
agree, okay.
May it please your lordship. Lordship, this is an application under 227, challenging an order dated 8/12/2025, whereby our petition under Order 1 Rule 10(2) for impleading us as a party in the suit was rejected. My lord will find the impugn order at page 31. Yes, my lord.
Yes.
May I read, my lord? The plaintiff is represented, page 31.
Yes.
The plaintiff is represented, no notice has been served as per the so and so upon the alleged legal heir and successor of a deceased defendant for production of the death certificate and legal certificate, legal heir certificate. Heard, learned advocate for the plaintiff to take steps on the issuance of the notice fixed 22/1/26 for hearing in NO. Now, my lord, may kindly turn to the next paragraph, my lord. Actually, my lord, on that day, this order was also passed. And the impugn.
Who are you?
I am a third party, my lord. I filed an application under Order 1 Rule 10(2) for impleading myself as a party in the suit because the suit land is in my possession. So my lord will kindly see later on at page 32, my lord. Seen petition number so and so by for adding petitioner as necessary party of the suit. Heard, learned advocate who has appeared for the petitioner. It has been submitted that the deceased defendant so and so gifted the suit property to his brother so and so since deceased as per personal laws and handed over the physical possession of the gifted land. That subsequently said Abdul so and so expired on so and so, leaving behind the petitioners as his legal heirs, and they are now in possession of the suit land. It has been further submitted that unless the said legal heirs are implemented as defendant, the real controversy between the parties cannot be adjudicated and decree passed in their absence will be infructuous. I have gone through the plaint of the instance suit. This is a suit for specific performance of a contract so and so dated whereby she so and so, deceased defendant of the suit has agreed to sell the suit land for total consideration of so and so, which he received so and so as an advance on the very day of the contract. Here the real controversy between the parties is the performance of the contract. Who is possessing the land is not an issue of this suit. The petitioners are neither a party to the contract nor they have come as a legal representative of the parties of the contract to be performed. No relief has been sought from the petitioners, and for deciding the execution of the contract, their presence is not necessary. Hence, the above petition filed by the petitioner to add them as party of the suit is not maintainable.
At what stage suit is pending?
Suit is pending, my lord, at this stage. My lord, the sole defendant has expired, my lord. Now the application.
So the substitution,
Yes, substitution process is going on, my lord. What
okay,
has happened, my lord, the sole defendant, my lord, has gifted to our predecessor interest this suit land in 2018, my lord. Since then, we are in possession. We filed an application under Order 1, Rule 10(2), saying that we are in possession. Even the defendant has also stated in the written statement, my lord, that I have gifted the suit land to late so and so, the predecessor interest of the petitioners, my lord. And my lord will find the written statement, my lord, at page
no, whom have you made respondent in this case?
the plaintiff, my lord.
And the defendants?
Defendant, my lord, because they are not disputing, my lord. Because the defendant, the sole defendant,
They have to also be made respondent.
that can be done, my lord. But my lord, at this stage, the substitution process is going on. The sole defendant has expired. The legal heir needs to be impleted first in the trial court. Thereafter, my lord, it can be done.
Okay. Where is? Heard Mr.
NBPC.
MBP Sinha. NBP Sinha, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 8/12/2025 passed by the Court of Learned Civil Judge Senior Division, Shankardev Nagar, Hojai, in title suit number 9/2025 22, whereby the prayer for impleading the present petitioners under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure in the aforesaid suit was rejected by the trial court. The contention raised in this revision needs to be examined by this court. Hence, issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days of the date of this order, returnable on 23rd February. Let also the scanned copy of the records of title suit number 9/2022 be called for from the trial court, list accordingly.
In the meantime, the proceeding will be stayed.
No,
Because I am ousted from the suit. my lord.
No, this is not your proceeding.
No, my lord. If the suit proceeds, my lord,
It is in the stage of substituting the legal layers.
with all
It will cause no harm.
my lord, I am ousted from the proceeding. That is why, my lord, I have approached this honorable court.
We will consider your prayer, but at this stage, when the suit is pending, at the stage of substituting the sole defendant,
Yes, my lord.
you will suffer no harm if the notices are, let the notice be served early.
My lord, if this my lord, if the notice has served also, my lord, for example, my lord, if notice has served also,
Yes.
my lord, even then also, my lord, I am, my lord, ousted because my petition has been rejected. The suit will proceed in my absence, in our absence.
No,
So,
let them
so-
appear. Let them appear and raise.
my lord, in the impugn order also, my lord will kindly see the plaintiff's stand was not taken into consideration by
No,
the
not
learned
at
court.
this stage.
My lord, with all
You,
respect,
you don't have a case for an ex parte ad interim relief at this stage.
Lord,
Should I reflect it in the order
no, no,
and
my lord.
close it?
My lord, I am ousted from the, my lord, suit, my lord. Because my petition has been rejected, my lord. If the suit proceeding goes on, my lord, I am in possession, we are in possession of the suit land, my lord. I am ousted from the suit, from contesting the suit, my lord. Only my prayer is there, my lord.
You are not outside, you are not included.
Yes, my lord. I'm ousted because, my lord, 22, if 20, section 22, my lord is
Wait
aware.
for the service of notice. After due service of notice, we will consider we are not closing your prayer stay.
My lord, then, my lord,
If you insist, I will close it now.
my lord, then, my lord, an observation may be made, my lord.
No.
My interim prayer may be considered on the next day.
If that prayer is there, if it is not considered, there is always a understanding that it will be considered. For that, an observation is not required.
Otherwise, my lord, the case will, my lord,
The prayer for interim relief would be considered after due service of notice on the respondent.
oblige. Okay. Leave your-
Commissioner, kindly pass over the matter for the time being. Mr. D. Chakravarti is on next.
What is the matter?
Eviction suit, lordship. I have a decree of eviction against them under rent control act.
Why are you praying for passing over?
Mr. D. Chakravarti is on legs in another.
Okay, let him come. Let's-
Hey, please, your lordship. If my senior is out of station, so I'm praying for an adjournment, lordship.
The interim order is.
Interim order is there. Heard Mr. Aiuddin, learned counsel for the petitioner. Also heard Mr.
Yes, Dev.
B. S. Deka, who learned counsel for the respondent, who prays for an adjournment on the ground that conducting counsel for the respondent is out of station. The learned counsel for the petitioner does not raise objection to the prayer. Hence, prayer is allowed. Let this matter be listed again on 13th of February. The interim order shall continue till next day.
Ablash.
For respondent, lordship, this case, they do not appear. It was dismissed, then they had restored, dismissed twice for default.
Last occasion also nobody appeared.
Ship. Earlier also two orders, lordship will find when it was dismissed. And they do not. And to us also, they are not served the copy.
We'll fix it day after tomorrow again. If they don't appear, we'll pass consequential order.
Right.
None has appeared for the appellant on call. Miss R.D. Majumdar appears for the respondent. On perusal of the record, it appears that on last two consecutive dates when the case was listed for hearing, no one has appeared for the appellant. Stop. One more chance is granted to the
My lord.
appellant.
Myself.
Yes,
Very
what
costly
happened?
is my name is not shown.
You,
My name
No,
is. not
at last he has appeared. I do not mind. I am safe from Thursday, lordship.
Yes, my lord.
Wednesday.
And it was
But
my
give
name-
me a copy of appeal.
Yes, my
memo.
lord. Yeah.
And it was dismissed twice. So. Budbariya ko gola.
you have filed wakalatnama in this case.
Yes, earlier I had filed a wakalatnama.
Okay. What is to be done now?
My lord, it may be
We-
fixed for fifth
Fifth?
February.
5th February. Okay.
Whether
My name may be shown.
this appeal is not yet admitted, we'll admit it.
He'll
Ah,
give copy that. of
Okay,
the appeal.
I continue. Heard Mr. B. R.
B.R.
Das, learned counsel for the appellant. Also heard Miss R. D. Majumdar, learned counsel for respondent. Respondent number, so only one respondent,
Yes, my
learned counsel for the respondent.
strike off.
Why you have not made driver and owner party?
My lord,
Actually, they are not necessary parties. Because of the award passed against the P number one and the same is satisfied.
This is for enhancement.
But
But
still, Lordship, it
owner
cannot
and
be-
driver would be, because she will be indemnifying them only.
My lord, trial court award was satisfied by the respondent one.
That doesn't matter. It cannot be admitted, Lordship, till they implement make the owner and driver party.
My lord, actually it was struck out by this honorable court also.
Where? When?
My lord, on the next date, I will inform them.
No,
Actually, my lord, I have not bring the record because of my name is not shown there, so I was unable to.
so we are not admitting it.
Yes.
You find out. And if on next date you remain absent,
No, my lord, out
will
of
not.
it,
Not Mr. B.R. Das, so and so. Learned counsel for the appellant submits that the appellant has not impleaded the driver and the owner of the offending vehicle, as they are not necessary parties in this appeal. He further submits that the award for enhancement of which this appeal has been filed has already been satisfied by the present respondent. That is the insurance company. And since this is an appeal only for enhancement of the awarded compensation, the presence of driver and owner may not be necessary. He further submits that he may be granted some time to make further submission on this point. Stop. On the other hand, learned Miss R.D. Majumdar, learned counsel for the insurance company, submitted that the owner of the vehicle, owner and driver,
Necessary and proper party.
owner and driver of the vehicle, offending vehicle are necessary and proper party. And this appeal and the appellant cannot choose not to implead them at the first instance. So, considering the submissions made by learned counsel for the parties, let this matter be listed on 5th of February.
Highly obliged.
Let the name of Mr. B.R. Das be reflected in the cause list as counsel for the appellant henceforth.
Yeah, please, my lord. My lord, make a possible, my lord, for the time being, my lord, two, my lord.
Why?
As per instruction of the senior Mr. A. Ganguly, my lord. Please appear, my lord.
At 2? Okay.
Keep your list.
I can find it.
Application lordship. Now, similarly, like in the other certainly possibility make for finding.
Yes, for the time being. We'll take it up after some time. None appeared for the petitioner when the matter was called for hearing. Let this matter be listed.
Item 10 and 53.
53 in video. Kota se. Let this matter be listed date at the 13th of February. Both.
Item number 12.
Regular first appeal.
Heard Mr. S. Dekar, learned counsel for the appellant. Also heard Mr. S. Das, learned counsel appearing for
ASIDC, Assam
for
Small
the
Industry.
respondent. This appeal under section 96 of the Code of Civil Procedure 1908 has been preferred by the appellant Messrs. Patkai Plastic Private Limited, impugning the judgment and decree judgment dated 15/11/2025 as well as decree dated 17/11/2025 passed by the Court of Learned Civil Justice Senior Division Tinsukia, whereby the whereby passed by Tinsukia in title suit number 52/2018, whereby the plaintiff's suit was dismissed. Issue notice and call for the records of the trial court. Since Mr. S. Das has appeared for the sole respondent,
One extra copy.
no formal notice need to be issued to the respondent. However, the learned counsel for the petition appellant is directed to furnish requisite copy of the memo of appeal, copies of the memo of appeal, along with annexure to the learned counsel for the respondent. List this matter after receipt of the trial court records.
Item 13. This is an first appeal, Your Lordship, against the judgment decree passed by Learned Senior Division number 2, Kabul Metro.
Heard
Judgment is of
Mr. K. Jain, learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure has been preferred by the appellant Shri Bhagirath Rangson alias Mikir, impugning the judgment and decree dated 11/7/2025 passed in title suit number 398/2015 by the Court of Learned Senior Division number 2, Kamrup Metro and Guwahati. You were the defendants.
I was for the plaintiff, Lordship. The suit was partly decreed, Lordship, and there was a counterclaim filed by defendant number
Stop.
5 and 6. So that was allowed.
Okay. Let the notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days of the date of this order, returnable on 23rd of February. Let also the records of the trial court be called for, registry to take steps for requisitioning the records. List accordingly.
Lordship, there is an IA also for stay of the MP order. As the honor, they have prepared one execution case. Lordship.
At what stage execution case is pending?
That is for report. Read has been issued, Lordship.
When it is fixed?
That is in fixed lordship on 20th of February.
What is the writ has been issued in the counterclaim?
In the counterclaim.
What was the relief?
Relief, you are was for recovery of possession.
The suit land is in your possession.
In my possession.
Heard Mr. K. Jain, learned counsel for the applicant. This application under Order 41, Rule 5 of the CPC, read with Section 151 of the said code, has been filed by the applicants, filed by the applicant in connection with the regular first appeal number 2/2026 filed by the present applicant, wherein he has impugned the judgment and decree dated 11/7/2025 passed by the trial court in title suit number 398/2025 by the Court of Learned Civil Judge Senior Division number 2, Kamrup Metro at Guwahati. Learned counsel for the petitioner applicant has submitted that the aforesaid appeal has already been admitted and notices are also issued to the respondent side. He further submits that in the meanwhile, where is the title execution case?
That has been filed, lordship, in the executing court, lordship.
Where is the mention above?
No, I've come to know, lordship, that today itself in the morning. That has been
Then
noted
we
as
are-
execution 73 of the 25, lordship.
73 of
25.
learned counsel for the petitioner has submitted that in the meanwhile, the respondent have already initiated a execution case which has been registered as title execution case number 73/2025, wherein the executing court has already issued the writ and the next date is fixed on 20 February 2025 for 26 for report. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondent today itself. Within a day from the date of this notice by speed post as well as by usual mode, returnable on 23rd February. Stop. Considering the fact that the connected appeal has already been admitted, as well as the executing court has issued writ in the execution case, the further proceeding of title execution case number, the execution of the impugned judgment and decree shall remain stayed till next returnable date, list according.
This will appeal for enhancement.
Heard Mr. M. Rahman, M. Khan, learned counsel for the appellant. This appeal under section 273 of MV Act, 173 of Motor Vehicle Act 1988 has been filed by the appellants / claimants impugning the judgment and award dated 16/9/2025 passed by the member Motor Accident Claims Tribunal Bongaigaon in MSC case number 14/2022. The appellants are aggrieved by the quantum of the compensation awarded to them and have prayed for enhancement of the same. Issue notice to the respondent. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 27 February. Let the records of the MSC case number 14/2022 be called for from the concerned tribunal. The registry to issue requisition, to registry to take steps for requisitioning the aforesaid records, list accordingly.
The next case is similar, out of the same incident, judgment dated same, only MSC case number 16.
Same order. Same order. Only the motor accident case is 17 of 2026. MSC case 17. Baki.
The here would be 16. Earlier one, it was 7.
This one is 17. No, okay. The MSC case number?
Earlier 14 and this one is 16.
MSC case number 16 of 2022. 16 of 2020. Remaining things as it is.
Bless.
Well, the basic point that we would like to urge under this order 43 rule 1R is that the golden principle which is required to be considered while passing an injunction order, that has been totally bypassed, man. And even a mini trial was done.
In this FAO,
Yes,
this FAO is yet to be admitted.
Yes, ma'am. And my lord, we have also a prayer for stay, my lord, because that the next date is on 3rd, my lord, February. My lord, consideration, my lord, required that lordship just look for a moment, impugn order for a moment, my lord. Page 144. There is not a single whisper, my lord. Page 149 is the operative part. Paragraph 8, my lord. Page 149.
What is the case?
The case is that, my lord, a paternal property between 4 brothers. Out of which, my lord, there is a common path, my lord, which now accessible to the all parties concerned. My lord. Now, my lord, so far the petitioner is concerned, my lord, because of the service exigencies, they have shifted to Canada, my lord. Now, once they have shifted to Canada, my lord, taking advantage of the situation, my lord, what happened in 2025, they put a iron gate in front of the gate. And even a nameplate was also placed on the front side of that gate, my lord. Now, since we have to enter into our plot of land, therefore, my lord, what happened until and they keep it in lock and key and the key was in their hand. Whenever required to enter into our plot of land, then we have to take a key from them. We have some tenants that they are getting, my lord, trouble to that, my lord, the accessibility of that particular plot of land because of their resistance. Therefore, my lord, so far the common path is concerned, my lord, which has been used by all parties concerned. Nobody has right to put any hindrances on that, my lord. But since this activity is done, therefore, my lord, we have filed in land grabbing case before the learned, my lord, the court bill. Along with, my lord, we have also applied for an injunction, order 13 and rule 1 application. At initial stage, my lord, it was considered by the learned court below that since this hindrance is not, my lord, permissible in the factual aspect, therefore, my lord, they were restrained from putting any, my lord, resistance to that front side of the gate, my lord. Afterward notice issued, they interferences, my lord, and my lord, they filed also an application under order 39 Rule 4, my lord, seeking, my lord, vacation of that earlier order. The both matter was clubbed together, finally order was passed. And in that order, my lord, a mini trial was decided, the mini trial was done to the effect that so far the accessibility is concerned, my lord, that is already given to them by way of a compromise deed, my lord. It is a totally misleading concept from the compromise deed seal of 2006, where it is clearly mentioned otherwise that it is a common path exists over that plot of land. Apart from, my lord, while deciding, my lord, order 39 rule 1 to petition, there is not a single whisper about prima facie case, irreparable loss, my lord, balance of convenience. In absence of, my lord, this three test, my lord, the order was passed, and, my lord, that earlier protection that was granted to me, that was, my lord, lifted up, my lord. Now, as of today, the situation is that a 75 years old lady is there, my lord. Suppose whenever they want to approach their, my lord, then they are getting a resistance, my lord. Now, lordship, a settled position of law in, my lord, Wanderer Limited versus Antox case is paragraph 14 very much clear, my lord. Until unless, my lord, we don't want to open the mate of the case, my lord. There is no need, my lord, the necessity to, my lord, that we have to go to the root of the matter, my lord, again, and seeking a reassessment of the factual aspect. But the legal point is that, my lord, once in paragraph 14 of the Wanderer, my lord, Limited versus Antox India, it is decided that if the learned court will fail to consider the three golden principles, then this order is suffering from the perversity, my lord, out of which this appellate court has the ample power to interfere with that order, my lord. My lord, to that extent, my lord, some other principle is also laid down by the Supreme Court that while conducting a, my lord, inquiry under order 39 rule 1-2, my lord, mini trial should not be taken place. But here is a case, my lord, a mini trial has taken place, which is, my lord, clearly reflected from the impugn order in paragraph 8, my lord. And even, my lord, the decision that has been rendered by way of this mini trial, my lord, it is out and out, my lord, contrary to the document available on record, my lord. Therefore, my lord, this is a fit case. Some legal points are there, require consideration of this honorable court. And, my lord, my prayer is that so far, my lord, the accessibility to the plot is concerned, my lord, it will not harm to them. But if they put this resistance, my lord, definitely, my lord, I would be sufferer, my lord. Lordship, can you see for a moment?
No, we'll admit the appeal.
But, my lord, so far this order impugn is concerned, my lord, that required, my lord, interference, my lord. Other
How?
reason is that, my lord, this
No,
order,
in what manner?
my lord. Well,
What manner you want
absolutely.
interference?
I'm trying to satisfy this one. My lord, order 41 rule 5 followed by order 43 rule 1.
No. My query is, how should I interfere?
Absolutely.
What should I do?
I will try to satisfy them.
Your injunction application was dismissed. Now what should I do at this stage?
My lord, can you see that in that impugn order, apart from, my lord, interference, some other imposition of cost was also given to me. My lord, can you see for a moment, page 150 of the impugn order, a 5,000 cost was imposed to me. I have applied for, my lord, injunction, a cost was imposed to me, my lord. And there is no any explanation on what basis, my lord, this, my lord, cost has
So
been
you
imposed.
want stay to that effect?
But this order itself required, my lord, otherwise, my lord, can you see, my lord,
How a dismissal order can be stayed?
my lord, dismissal of, because, my lord, if suppose this would be stay for a moment, my lord, because this is the order where, my lord, the injunction was rejected.
No, you make me understand how a dismissal order can be stayed.
Yes. But if this is suffering from perversity apparent on the face of the record,
Yes.
then this honorable court has ample power under order 41 rule 1 or 41 rule 5 to interfere with that, my lord, order. I would be benefited or they would be benefited. This is separate aspect. But prima facie, my lord, if that basic contents shows that this order not sustainable, my lord, then this has to be stayed, my lord. The relief, whatever granted, not granted, that is a separate aspect, my lord. Lordship is now exercising only appellate power, my lord. See the perversity. And perversity, my lord, it is on 2 counts. First, 3 principles are not there. Second, mini trial was done, my lord.
What would be the implication of stay?
Stay that, my lord. First, I have been imposed a cost of 5,000.
That would be stayed.
No, my lord. Thing is that, my lord, 5,000 is the integral part of the findings, man.
Okay, what would be the implication of this stay?
Stay is that, my lord, if suppose this would be stay for a moment, my lord. Other now they are getting a free hand, my lord. At least I could have pursued that, my lord, my claim about my accessibility, my lord. The whole case is about accessibility, my lord. I am the petitioner there on, my lord. If, my lord, I'm entitled to get that relief, my lord, and this order is suffering from that.
No, no, you are not getting me.
Sorry.
My understanding is, apart from stay, you ought to have prayed for interim.
Yes, sir. My lord,
in
my lord, that will be, my
Order
lord, we'll
39.
pray afterward, my lord, because it is admitted. position that-
Because a dismissal
Yes,
order cannot be
Yes,
stayed.
ma'am. Dismissal order to the extent of lordship may stay for a moment, my lord, of that imposition of cost.
Imposition of costs.
Cost, my lord. And second aspect, my lord, if suppose this order be stay, my lord, reason is that, my lord, on 3rd February 2025, 26, my lord, the matter is fixed for admission, my lord. And my lord, it has a ramifications of this order to that admission, my lord, because the learned court will take, only took a view. And suppose if this view will be continued, my lord, then that shadow will be reflected to that, my lord, my submission advance for the purpose of admission, my lord. Because on last occasion, the learned court will already say that I have already passed my order.
Yes. You have anything to say?
Yes. My lord, first of all, contrary to the submissions made by my learned friend, my lord. My lord, this is a case wherein there is a stark misrepresentation, my lord. Now the submissions are being made that it is a paternal property, but all throughout the pleadings, my lord, in the lower court, trial court, my lord, the pleadings are that they were the absolute owners of the property. Now the submissions are being made that the property is a joint paternal property, which is correct. Now they are differing from their submissions, differing in the submission. The pleading which was made before the learned trial court was that it's a property which is the absolute property of the petitioner, the appellant hearing. Now
No, just a minute. The cost was imposed because court came to a finding that you gave misleading and misrepresentation.
Yes.
Unless,
My lord, the misleading, my lord, there must be explanation to the extent that what misleading, my lord, I have made. It cannot be a blanket order. And second thing is that in injunction petition, my lord, only because reason is that, my lord, kindly see, I would try to satisfy that why this court was imposed, paragraph 8, my lord, kindly see.
yes.
One line is very much clear because it is my duty to clarify the position. Paragraph 8 says, my lord, it is not filed that written objection to said application under order 39 rule 4. A bare page of the said written objection reveals that the petitioner have not specifically denied aforesaid requirement of the application under order 39 4 of the more particularly that the petition of the petitioner and respondent and their three others jointly purchase a plot of land which includes scheduled land. That petitioner have no form of requirement to use the scheduled C passage of the land as they have direct access of their scheduled A property by the side of the main road. That the respondent have been using the scheduled C passage since 1983 and there is a registered deed of compromise 23/2006 whereby the scheduled C passage of the land was left open to ingress and egress of the respondent. In fact, the said compromise deed is even relied upon by the petitioner in their said written objection. Now, just lordship kindly see the compromise petition, man. Page 106. What does it contain? My lord, in paragraph, this compromise petition, they are taking the seal that the rights was given to them. Lordship, just look for a moment, page 103, third paragraph.
Yes.
And whereas the first party is and has been in possession of the plot of land covered by the number 375 of the Pata number 76, which is part and parcel of a scheduled land, along with L-type Assam type house standing thereon, which is more particularly described in Schedule B thereto, and a small strip of the land measuring L on the northern western portion, more particularly described in the Schedule C hereto, falls in the share second part. It is never said that this strip was in possession of the first party. First party is the respondent here. It is clearly says second party, that means another brother. Now, lordship, just look for a moment, another aspect. Page 106. I just want to show that it's a common road. Page 106, paragraph 4. That the ingress and egress to the B schedule and C schedule and shall be in existing of 12 feet wide path furnishing to the east-west direction to be between the plot of Chandranath Sharma and Harinath Sharma and 6.0 wide path running in the north-south direction is between the plot of the second and the third party. And the said Sri Harsana Sharma, which was alternatively being used by the first party, shall cease to be the ingress and egress of the B and C schedule rate
Okay,
and
okay,
neither.
we'll examine.
Now, Lordship, only one line, 108, man, only one line, man, 108. 108, first schedule, eastern part. Common private 12 feet path and Harinath Sharma. It is clearly mentioned, common path. How they can, my lord, put resistance, my lord? And it is their own signature in there, compromise, and they relied upon. So therefore, my learned court below misread this contention and impose the course on saying that we misleaded the facts. And what misleading facts, my lord, that has not been revealed, my lord, in that appeal order.
My lord, this in page number one.
No, we are issuing notice at this
My
stage.
lord may not interfere with the lower court order, my lord. It's a reasoned order because there is this compromise deed was filed by us. They had not filed it along with their application in the land grabbing case. We had in our written statement filed
Maybe a
this,
separate thing, my lord.
and
Maybe
they
a-
had misled the honorable court and had been able to get the order. As such, the order is a well-reasoned order. They had said like the land is their absolute property, which is absolutely false because there is a sale deed where all the four brothers are.
My
the
lord,
party.
Mate is a separate thing, my lord. We are not on mate, my lord. In appellate forum, my lord, only see that whether perversity exists or not. My disputed facts, we can say anything.
My lord, they had
another-
misled the honorable court and had been able to get the
What misleading, my lord?
ad interim order, my lord. This is not a case of land grabbing.
Heard,
Because there is no criminal intent here.
heard, Mr.
Criminal intent.
The
has to be-
question of staying the dismissal order does not arise. Though we may stay the imposition of cost at this stage.
No, my lord, the cost has been imposed because there. has
We
been
will
misleading-
consider if it is rightly imposed, that will prevail, but we have to examine.
Yes.
Heard Mr. S. Chamaria, learned counsel for the appellant. Also heard Mr. K. R. Borwa, learned counsel for the respondent. This appeal under Order 43, Rule 1 within bracket small r of the Code of Civil Procedure, 1908 has been filed by the appellants impugning the order dated 12/8/2025 passed by the Court of Learned Additional District Judge number 1 Kamrup Metro in Miss J case number 52/2025. Filed in Miss J case number 26/2025 arising out of special LG case number 7/2025, whereby the prayer for grant of temporary injunction to the grant of temporary injunction by the present appellant was dismissed and a cost of ₹5,000 was imposed on the appellants by the trial court. Issue notice stop since Mr. K. R. Borwa, learned counsel for the respondents, have appeared for all the respondents. No formal notice need to be issued. However, the learned counsel for the appellant shall furnish copy of memo of appeal. You have received. Yes, a line to nagar. Let also the records of Ms. J case number 52/2025 be called for, as well as scanned copy of the Ms. J case number 26 and scanned copy of the special records of special LG case number 7/2025 be called for. Let this case be listed on 26 February after receipt of the aforesaid records.
5,000, that has been stated.
This interlocutory application has been filed by the applicants in connection with the first appeal against order number 63/2025 for 2025, under order 41 rule 5 of the Code of Civil Procedure for stay of operation of order dated 12/8/2025 passed by the Court of London, additional district judge number 1 in Miss J case number 52/2025. Filed in Miss J case number 26/2025 arising out of special LG case number 7/2025. Stop. Learned counsel for the petitioner has submitted that by the aforesaid order, the trial court had rejected the prayer for grant of interim grant of temporary injunction in favor of the petitioner. Stop. And has also imposed a cost of rupees 5,000 on the ground that misleading facts and misrepresentation was made by the petitioner in his application under Order 39 Rule 1 and 2 filed before the trial court. Learned counsel for the petitioner has submitted that the petitioner has impugned the aforesaid order by filing the connected first appeal against order number 63/2025, which has already been admitted by this court, and notice has been issued to the respondent, and the trial court scanned copy of the trial court records were also called for. He submits that the impugned order has been challenged by the petitioner, by the applicant in the connected FAO, mainly on the ground of perversity, as well as on the ground that while dismissing the prayer for grant of temporary injunction, the three golden principles were not discussed by the trial court. He further submits that the observation that the petition applicant has misled and misrepresented the trial court are also not true, and same has been challenged. Stop. Challenge in the connected FAO. He submits that initially by order dated 19/3/2025, the trial court had granted ad interim ex parte injunction against the present respondent. However, by the impugned order, same was vacated. On the other hand, learned counsel for the respondent has submitted that the trial court has considered all the aspects of the case and correctly decided the application under Order 39 Rule 1 and 2, as well as the application filed by the present respondent under Order 39 Rule 4 of the CPC by vacating the impugned order. vacating the order, interim order of temporary, ex parte in ad interim temporary injunction order. Stop. This instant application has been filed under order 41, Rule 5 of the Code of Civil Procedure, which is applicable for stay of execution of the stay of execution of the decree or order of the court which is challenged in a court. Since the order of dismissal of the temporary injunction passed by the trial court is not amenable to any execution, hence in respect of the dismissal order, this application under order 41 Rule 5 is not maintainable. However, as regards the imposition of cost of rupees 5,000 on the applicant, the same needs to be examined hence examined in the connected FAO number 63/2024. Hence, during the pendency of the connected FAO number 63/2024, 2025, the petitioners, the direction to the petitioner for deposit of cost of 5,000 to the DLSA Kamrup Metro shall remain stayed during the pendency of the connected first appeal against order. With above observation, this interlocutory application is disposed of.
My lord, an observation may be made. This order will not affect the progress of the land grabbing case.
That is not
No,
an issue, my lord. Let the
I have,
prayer-
I have not mentioned anything, any such thing in the order. I have clarified that this IA is not maintainable in respect of other. Only in respect of the cost it is maintainable, which is state.
Obliged.
My apologies, my lord. I was on lights.
Yes. What is this?
My lord, it's a concurrent eviction decree, ejectment decree against me. And an old one at that one.
You are tenant,
I was sub-tenant.
subtenant.
My learned friend has jumped before me in saying, but it is an admitted position that I was the subtenant of the tenants who were the principal defendants in the suit, along with the subtenants. All were arrayed as defendants in the suit. The suit was of 1991, my lord. Title suit number 37 of 1991, in which the plaintiffs represented.
We'll admit this CRP.
Lordship, this is under Rent Control Act. There are clear finding of defaulter, bona fide requirement, as well as of violation of section 5(1)D. There is subtenancy without permission of the landlord. Lordship. So this, my humble submission is this petition is liable to be dismissed at the first hearing only, because it is not deserved to be admitted. It is a rent control under Rent Control Act. Suit was of 1991. Suit was decreed in the year 2004. They preferred appeal and 21 years in appeal, Lordship. We are in-
Well, okay. What is your ground?
My lord, firstly, to counter my learned friend's submission, now, insofar as his status currently, he no longer remains the landlord, madam. That is something that he obviously will, my lord, apprise this honorable court. But in my contention now, the grounds that I have taken in this revision petition, my lord, these grounds are basically in regard to the subsequent developments which took place
during the pendency of the appeal that we had filed challenging the eviction decree. Now, insofar as the eviction decree is concerned, that is pursuant to the suit filed by the plaintiffs herein, who had filed the eviction suit for alleged default on the part of the tenants in payment of rent, bona fide requirement, and also on the allegation of relegating the tenancy. In the sense, they have also brought in the allegation of Section 51D of the Assam Urban Areas Rent Control Act, saying that the principal tenants are not authorized to sublet the tenanted premises to the subtenants who are now before your lordship. The subtenants are before your lordship, not the principal tenants. But we had countered the contentions in our written statement while contesting the suit, saying that the requirement under Section 51D, though not explicitly, but was impliedly complied with, where the permission from the plaintiff was taken for the subtenancy, and we had purchased the tenancy rights from the original tenants, and so we became the subtenants, and we had been tendering rent to the landlords at that point of time. But now, here at this distance of time, my lord, these are facts which I am not going to make submission of, my lord. Here is a situation where, during the pendency of the title appeal number 30 of 2004, there was a suit filed by a stranger to this eviction suit. He, being one Raj Sekhar Shah, had filed a title suit bearing number 128 of 2012, which attracts the suit premises. And he got an ex parte judgment and decree in his suit on 26/3/2013. All this I have annexed in my petition, madam. And then he put the ex parte decree into execution by title execution number 16 of 2013. And in the execution proceeding, he got symbolic possession of his decretal land, which includes the suit premises, in which we are under possession, madam. My lord, am I being clear, my lord? Here? The stranger to that earlier eviction suit filed the suit subsequently.
No, in this revision petition, on what ground you are?
My ground here remains. We have challenged the appellate judgment and decree.
On what ground?
The appellate judgment and decree confers the judgment and decree of the learned trial court. Now, the learned trial court had passed the decree in the year 2004, when admittedly, my lord, the respondents herein, who were the plaintiffs in the title suit, they were the landlords. But pursuant to these subsequent developments, today, they are not the landlords. As on date, they are not the landlords. In fact, the ownership has now transferred, or the ownership has now shifted, the title has now shifted to that stranger, to the eviction decree.
Whether that can be decided in this
That
revision.
is the reason we made our endeavor, not only we, my lord, in fact, insofar as the stranger to that eviction suit, he had also in between, during the pendency of the title appeal, filed various petitions before the learned first appellate court, where he wanted to get himself impleaded in the title appeal. We also filed petitions. All those things were rejected. And during the adjudication of the appeal, these facts, these vital facts, have not even been taken note of. But my humble contention remains that today, if they are seeking, because in the plaint, your lordship sees their prayer is for recovery of khas possession by evicting the defendants.
Have you filed execution case?
Not yet, lordship. It is just recently it has been decreed by the appellate court. Now, we has completed.
No, I'll just take a few moments more, my lord. Your lordship kindly sees, just my lord, on the basic aspect, my lord. In the plain, if your lordship kindly sees the prayer.
No, I have understood your submission.
They are praying for decree for khas possession of the suit premise by evicting the defendants. That is the prayer in the suit which was decreed. Against that, we filed title appeal. During title appeal, ownership changed. Possession symbolically got conferred to the person who got the ex parte decree in the subsequent suit. We remained in possession as tenants or as subtenants.
This you brought to the notice of
the learned appellate court. During the appeal, this development had taken place.
What was the observation?
There is no whisper in the impugned judgment. That is our bone of contention, my lord. Because now my humble contention is whether my learned friend or his clients can get this decree executed. They no longer remaining the landlord of the suit premise. Can they say that they are entitled to khas possession?
Where are your grounds?
My lord, lordship will kindly see. Your lordship kindly sees, this is the only aspect on which I have challenged this impugned appellate court's order. Page 25, ground number 4. For that, the learned court below also showed apathy in appreciating the vital aspect that while both the principal respondents and Rajshekhar Shah, who is the stranger, were claiming that they are the landlord of the suit premises, that issue was put to a conclusion with the dismissal of the application filed by the respondents herein under Order 21, Rule 99 and 101 CPC, and the claim of title and ownership of Rajshekhar Shah over the suit properties, including the tenanted premises under the occupation of the petitioners, on the strength of a lawful decree being upheld. Question of landlord-tenant relationship between the respondents herein and the petitioners could not have been determined, as the respondents herein ceased to be the owners of the tenanted premise and therefore not entitled to execution of a decree of ejectment of the petitioners from the state premises under the provisions of the Assam Urban Areas Rent Control Act 1972, as such the impugned appellate judgment and decree is bad in law. And this also is another aspect which I beg to draw your lordship's kind attention to. The ex parte decree that was obtained by the stranger, that was challenged by the clients of my learned friend, who are the plaintiffs in that eviction suit, and that has been dismissed. The ex parte decree, which attracts the suit premises, that was challenged under Order 21, Rule 9901 CPC by the plaintiffs of that eviction decree, and that has been dismissed. So as on date, my lord,
yes,
they are not the landlords.
Yes.
Your lordship, whatever submission is made, it's not only correct. Firstly, they have made an application for amendment before the appellate court, amendment of the appeal memo to bring this on record. That was rejected. They preferred a CRP before your lordship, and it came before your lordship also. Lordship was not convinced to grant any stay. Thereafter, in subsequently, they have withdrawn it because appeal was disposed of. The CRP was numbered 425, CRP IO 425 of 2025, withdrawn. Now, they are saying we are no longer a landlord, owner. This is not correct. Because under Assam Urban Areas Rent Control Act, we are the landlord. Landlord is defined there. Who is landlord? And they have also admitted we are the landlord. It is admitted fact. And this is a suit for eviction decree between landlord and tenant. Relationship is there. Now, we have not sold out to any third party online. The other person, they are saying Rajshekhar Shah, he was also one of tenant, and he purchased his premises, his suit premises, his premises over which he was tenanted from one of our co-sharer. Now they are trying to take advantage of this. That too by a decree of specific forms of contract. He has purchased.
No, the stranger has filed an execution case after getting ex parte decree.
Ours, it is not in our, this premises, lordship. They are saying this premises, this is not in these premises. And these things are not on record in entire suit or appeal. Here, only question is whether there is a landlord-tenant relationship and whether conditions for eviction are fulfilled, grounds for evictions are fulfilled. This is a suit for eviction of tenant under Rent Control Act. And who is the landlord, lordship? And it is admitted fact in the written statement also. We are landlord. They are saying the status is
No, let us examine the issues. Let us admit it, because now there is no execution case is pending. So grant of any interim relief is not there.
lordship, 40 rupees rent they were paying. In 2025 also that is going on,
No, we'll dispose it off.
without any stay, lordship,
Stay will not grant
lordship.
because there is no such prayer.
Prayer, my lord, is in so far as stay of the impugned appellate judgment and decree.
Under what provision?
The provision, my lord, it is a petition under section 115 of the Code of Civil Procedure, your lordship, on being prima facie satisfied, may grant me a stay of the impugned judgment and decree which is impugned here. Because the moment your lordship is admitting it, I am establishing a prima facie case.
It has come for motion perhaps today.
Yeah.
So it may come in column, admission column and dispose.
No, your lordship, my lord, expressed the inclination to admit this.
Because it is today in motion
If your
column.
lordship admits and call for the records, then I am, my lord, establishing a prima facie case before your
No,
lordship.
there is no execution case pending. So what is to be stated?
The impugned judgment and decree that of the learned appellate court, that may be stated.
Already 34 years have passed also.
All these are there, but my bone of contention is they are not entitled to, because they are now.
New ground cannot be, this is not appeal, this is revision.
Your lordship will see, my learned friend says that these are facts which are not my lord, relevant to their case. They have filed a
Because
petition under order.
Re-appreciation
order
evidence is not-
21, rule 99 and 101. I have annexed that petition under in page number 194. And in that your lordship sees their prayer and the schedule that they have stated. They are saying that the ex parte decree obtained by the stranger is the same as their decree in the eviction suit. At page 199, it is clear. Now he is making a submission that these are not, the two premises are not similar. Then what was the reason, what was the good reason on this earth to have filed the petition under order 21 rule 99 against that ex parte decree by the stranger?
Law is settled, our status of landlord cannot be changed.
My lord, who is a
It is
landlord?
Assam
As per
Urban
the
Areas Rent
definitions
Control Act,
of-
landlord is been defined
Under
here.
Assam Urban Areas
And
Rent
today's-
Control Act, a landlord is somebody who has to be the lawful owner of the premise. Now pursuant to that decree,
Okay, you are praying for stay under what provision?
my lord, this for the time being will be under section 115 of the.
Which provision?
My lord, section 115 of the Code of Civil
Read
Procedure
that.
in revision, my
Read.
lord, your lordship can excuse.
115.
My lord, will kindly see that this honorable court may call for the record of any case which has been decided by any court subordinate to such honorable court and in which no appeal lies thereto, and if such subordinate court appears to have exercised the jurisdiction not vested in it by
Now
law.
you directly come to the point.
My lord,
1153.
my lord, 3, a revision shall not operate as a stay of the suit or other proceeding before the court except where such suit or proceeding is stayed by the high court. So this power is vested by in this
Oh,
honorable.
which power?
My lord,
Stay of suit or proceeding.
Now-
So there is no such.
as of now, the
pending.
execution has not been filed.
So what is to be stayed? There is nothing to be stayed.
My lord,
Judgment cannot be stayed under 115.
my lord.
Heard Mr. D. Chakravarti, learned counsel for the petitioner. Also heard Mr. S. D. Purkayastha, learned counsel appearing for the
Respondent number 1 and 2, lordship.
this one. Aviator / respondent number 1 and 2.
Rest of the respondents, lordship, my humble submission, they were defendant. Against them, eviction decrees has attained finality, lordship.
My lord, if your lordship, my
Issue
lord,
is, notice is not required to be
if your
issued.
lordship does not issue notice to the other respondents, I am not, my lord, opposing that content.
No, at the first instance, against them,
They were a defendant. Against them, the eviction decrees. This attained finality, same eviction decree, lordship. They did not prefer appeal. Their 4 persons have preferred appeal, and they have now filed this revision petition. lordship.
stop.
3-2,
This
done.
application under section 115 of the Code of Civil Procedure has been preferred by the petitioners, impugning the judgment and decree dated 11/11/2025 and 14/11/2025 respectively, passed by the Court of Learned Civil Justice Senior Division number 2 Kachar in title appeal number 30/2024 arising out of title suit number 37/20/1991, whereby the appeal filed by the present petitioners was dismissed and the decree of the trial court was upheld. Stop. Let the notice be issued. Since Mr. H.D. Purkayastha has appeared for respondent number 1 and 2, no formal notice need to be issued against the said respondents. As against respondent number 3, 4, and 3, 4, 3, 4, 5, 6, 7, and 3 to 10 are concerned, it is submitted by learned counsel for the petitioner that they were also the defendant in the title suit and had not preferred any appeal against the decree passed against them, and therefore the judgment and decree passed against them have attained finality. He further submits that their presence may not be necessary for disposal of the instant revision petition, and therefore he prays for dispensing with the notice to them. The prayer is allowed. Let the scanned copy of the records of title appeal number 30/2004 and records of title suit number 37/1991 be called for from the respective courts. Let this matter be listed again in the admission hearing column on 26th of February. List accordingly.
Getting under order 41, item 17 and 18.
Make the lordship in item 17 and 18, I have been requested by MS Roy to make it a pass over for the time being. Lord.
Item 19.
19, lordship, I am appearing and for the appellant. In this case, the appeal has been preferred by the defendant. There were two defendants. I make one of the defendants as pro forma, lordship. Suit was filed by the two respondents, lordship, page 8, annexure 1. The case of the plaintiff is that, lordship, their vendor allowed us to stay over the suit land as a tenant, lordship. And thereafter, they approached us for selling the suit property, to which the defendants denied, lordship. They said that you can sell it to anyone else and I will, lordship, vacate the land. Thereafter, the vendor of the plaintiff sold the land to the plaintiff. It is the case of the plaintiff, lordship. And the entire plaintiff, they have admitted.
But suit property remains in your possession.
My possession, they have admitted, but they said that I am the tenant of their vendor, lordship. And thereafter, suit was filed on the basis of that registered deed for vacation, recovery of possession, lordship. Right title interest and.
By whom? By the new purchaser.
New purchaser, lordship.
Okay.
And the defendant 1 and 2 appeared and filed their written statement along with counterclaim, lordship. They said that the suit land was purchased by the defendant in 3 plots, lordship. Their father purchased by exhibit A 1 bigha of land, and the defendant purchased 1 bigha of land by unregistered sale deed, and their father again purchased 1 bigha 2 katha 10 lesa through a by giving the consideration amount, but no sale deed was executed since the year 1970, 72, and 80. This is the case of the defendant. Plaintiff's case, this, the lordship, he purchased in the year 2008. Lordship, kindly see page 13.
No,
paragraph-
your case is that who purchased in 3 shares?
Lordship, my father
Your
purchased.
father.
My father purchased 1 bigha, 2 katha, 10 lesser.
How much is this woodland?
They mentioned that 5 bigha and 16 lesser. Page 14, lordship. Land measuring 5 bigha, 16 lesser out of the total
Entire 5 bigha 16 lecha was purchased by your father.
by plaintiff, lordship. And our case is that, lordship, we have purchased 3.5 bigha.
Out of this.
Yes.
And remaining land?
Remaining land with the vendor, lordship. Our case is that the remaining land with the vendor. And he filed.
You are
against
on possession over this 3 bigha,
3.5 bigha. lordship.
3.5 bigha only.
Yes, lordship. Since 70 to 80 years, and it is admitted by PW5 also.
What was held by the trial court?
Trial court had, lordship, in exhibit A, there was a mistake. Dark number, instead of 813, only 81 was inserted. So my exhibit A registered deed was not taken into
Sale deed.
consideration. Yes, lordship. Sale deed.
And there were 3 sale deeds.
Yes, lordship. No, lordship, 2 sale deeds. One is registered sale deed. There is a mistake in Dag number. And one is a unregistered sale deed, so it was not taken into consideration. And third pleaded case of the defendant is that their father given the consideration amount 7,000, but no registered sale deed was executed by the defendants due to their health condition, lordship. So this is a compact area, so the defendants are possessing since 60 to 70 years, lordship, over the suit land. And this is admitted by the plaintiff in his plaint and as well as his all PW's, lordship. And we are residing by constructing our houses thereon, lordship. May I take your lordship to the plaint, lordship.
No, before that,
Lordship.
what was your plea before the appellate court?
Appellate court, my plea is page 27, lordship. And from 26, paragraph 11. I have clearly mentioned that I have purchased 3 plots of land, lordship. That the plaintiffs have no right title, page 26. Paragraph 11. lordship.
This plea was not considered by trial court because
Because, lordship, there is a mistake. in-
mistake in the, and one sale deed was
Even if-
unregistered.
So even if it does not confer any right title interest, but it shows that since 1966, I am in possession. The dark number is 813 and the 3 was not there in the sale deed, lordship.
And the appellate court,
Both the court held same way, lordship. Affirm the
what are the substantial question of law which you have formulated?
lordship. Page 6, lordship. 1, 2, and 3.
These appears to be question of facts.
Lordship, by that time, the vendor has already relinquished his title, lordship. He already abandoned his title in favor of the defendant's father and in the defendant, lordship. So the registered sale deed which was executed in favor of the plaintiff, it is an illegal sale deed, lordship. Who by that time, he already lost his title, lordship. Even if my registered deed exhibit A was not taken into consideration, but it can be taken into consideration to show the adverse position of the defendant, lordship. It was within the knowledge of the owners that we are possessing the suit land. Until 2008, he did not try to vacate us, did not pass any notice.
You took, whether you took the plea of adverse possession.
That in the written statement that was there, that it is within the knowledge of the owner, we are possessing.
Whether any issue was framed.
No, no issue was framed, but the adverse possession plea was considered by both the courts, saying that as we have taken a plea of purchase, lordship, so the adverse possession plea cannot be considered.
Court
That-
has made such observation.
Yes, that was the observation.
Now, what substantial question of law is involved?
Ship 1, 2, and 3, recovery of possession given to the plaintiff only on the basis that his right title was proved. So he is entitled for recovery of possession, whereas the plaintiff, he himself admitted in plain that only formal possession was given to the plaintiff at the time of execution of the registered sale deed. And he stated that thereafter he approached the defendants to vacate the suit land, then the defendants denied. There was a assurance by the defendants in favor of the plaintiff and in favor of the vendor of the plaintiff that we will vacate the land. It is their pleaded case, lordship. But it is our pleaded case that as we have purchased the lands and we were possessing since 19.
No, purchase you are unable to prove.
One sale deed is there, lordship. That was not taken into consideration.
No, there is no sale deed. In one case, you have not mentioned the DAG number.
Lordship.
Instead
Sale
of
deed
811,
unregistered. That is, lordship, sale deed. Registered sale deed. the
instead
mistake
of
in the-
813, you have mentioned 81 only.
Lordship.
So that cannot be regarded as pertaining to the suit land
Yes, lordship.
unless that is rectified.
Lordship. From that, and now as there is a plea of possession by the defendants in their written statement, from that registered sale deed, lordship, the date of possession is reflected. So since then, the defendants are possessing, so they perfected their title by adverse possession. lordship. So by my understanding, lordship, there is a decision of this Bombay collector.
So,
Collector of Bombay, lordship.
so you are pressing on the plea of adverse possession.
Yes, lordship. One portion, lordship. And one portion, there is a registered sale deed of 1 bigha of land. I have purchased from Liaquat Ali and Liaquat Ali purchased from original vendor. That plea is also there, lordship.
Why it was not accepted by the trial court?
The trial court said that, lordship, this 1 bigha is out of suit land, lordship.
How the trial court is wrong?
Lordship.
Why the trial court is wrong?
Lordship, that I have preferred another regular second appeal against the dismissal of counterclaim. That substantial question of law I have formulated in that regular second appeal. Here I am.
Whether that has been admitted.
No, lordship, that is not yet numbered, lordship. This is the first one against the decreeing of the suit, lordship. In this case, I am, lordship, submitting that the plaintiff's suit cannot be decreed, which was decreed by the first appellate court and the trial court on the basis of the registered sale deed, which was executed by the vendor when he has no title, lordship. Lordship will send issue number 5, lordship, that is plaintiff's right title and interest. Page 51 by trial court, lordship.
Okay. Whether any execution case has been filed.
No, lordship. But I have filed my stay petition. Your lordship may issue notice if your lordship is admitting this regular.
Heard
second
Miss R. Chaudhary, learned counsel for the appellant. This appeal under this second appeal, this regular second appeal under section 100, read with section 47, 42 of the Code of Civil Procedure 1908 has been preferred by the appellant, namely Amir Hussain, impugning the judgment and decree dated 22/9/2025 passed by the Court of Learned Civil Judge Senior Division Hojai in title appeal number 1/2021, whereby it affirmed the decree and judgment dated 11/9/2019, sorry, 11/4/2019, passed by the Court of London, Civil Judge Junior Division, Sankardev Nagar, Hojai, in title suit number 47/2009. Whereby the suit of the respondents/plaintiffs was decreed. After considering the submissions made by learned counsel for the appellant, and after going through the materials on record, following substantial question of law is formulated in this appeal. Stop. Next dash within inverted comma. Whether the judgment and decree passed by the appellate court as well as trial court are perverse to the extent it declared right of the right title and interest of the plaintiffs/respondent over the suit property on the basis of a registered sale deed which was executed in the year 2009, whereas the plaintiff was divested of the right title and interest over the said property, as the said property was in possession of the present appellant for last 60 to 70 years. And
By constructing houses.
60 to 70 years by constructing houses thereon, and whether the trial court and appellate court appellate court committed perversity in not considering the plea of adverse possession raised by the petition. You have raised plea of adverse possession
Continuous possession is there.
raised by the present appellant before the said court. Stop. Inverted comma close. Issue notice to the respondents. The appellants shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 27th February. Let the records of title appeal number 1/2021 and title suit number 47/2009 be called for from the respective courts. List this matter accordingly. In IA,
Registered deed of 2008. I have mistakenly written 2009.
2009 or जगह 2008 लिखो.
In IA, worship
Open. In IA, issue notice, same date.
interim prayer be considered if any execution case has been filed.
Interim prayer will be considered after due service of notice.
Obliged.
Yes.
From the court of honorable district judge Tezpur to the honorable court of district judge Bongaigaon or any other appropriate court within the district of Bongaigaon. The marriage was solemnized in Bongaigaon and the parties started residing together at Tezpur. Admittedly, the respondent, the husband,
Check your mic. Yes,
am I audible?
yes.
The proceeding, I am praying for transfer of a divorce proceeding filed by the husband, your lordship, at Tezpur from Honorable District Judge Tezpur to any appropriate court within the district of Bongaigaon, your lordship.
Your wife.
I am the wife. The proceeding of divorce was filed at Tezpur by the husband. The marriage was solemnized as Bongaigaon, your lordship. Thereafter, the parties resided together at Tezpur. So they have filed the divorce proceeding at Tezpur. Lordship, my ground for transfer is, your lordship, there were allegations and there were cases of 498A and other cases, criminal cases at the lordship, which are now the respondent has been acquitted, admittedly. But nonetheless, there were prima facie cases which shows that there were physical harm and physical assault on the petitioner. And the case initially, the criminal case was initially filed at Tezpur only. While she came back, while she was driven out of the matrimonial house at Tezpur, she filed an FIR at Tezpur and then came back to Bongaigaon to reside with the parents, your lordship. So my ground for transfer is that she is not working and she is residing with the aged parents. I have annexed the Aadhaar cards of the parents showing that they are 85 years and not parents. Father is more than 85 years as on date, your lordship. And the mother is also aged. Brother is there, but brother is staying separately after his marriage. He is not staying with the petitioner. And another thing, your lordship, there was an order of maintenance against the petitioner, against the respondent herein. He did not pay up the maintenance. I had to approach this honorable court by filing writ petition criminal. Thereafter, I was directed to go and approach the concerned court. I have filed a case for that maintenance, that area maintenance as well, your lordship. And as evident from one document annexed by them at page 79, which shows that they have received a notice.
Where the maintenance case is pending?
At Bongaigaon, your lordship. Before JMFC Bongaigaon. Maintenance case is decided, he is not paying up. So at page 79, there is a notice that has been received by them, which shows it was wrongly typed, I don't know how, along with her children. There is no children, there is no issue to the parties, your lordship. At page 79, maintenance amounting to 1,500 per month. He has not been paying, your lordship. So the arrear maintenance till current month, 1,59,000. He has received notice for that. And till date, to my instructions, there is no payment of maintenance. This is what my submission is, your lordship, and they have filed an objection, your lordship, annexing all the cases, criminal cases wherein they have got acquittal. So my submission is that acquittal in a criminal case does not prima facie show that their divorce case which they have filed is to be decided in their favor. They have paid for a divorce. I have not, and they have filed it at their own place. I am staying at Bongaigaon with my aged parents.
When the divorce was filed?
It was filed, your lordship, 2024, your lordship. Date of filing is, case number is TSM 124/2024. Page 31 is the summons that I have received, your lordship.
And when you have separated from your husband?
Lordship, long back, your lordship.
Since at least 2012.
2000.
They last resided together, at least since 2012.
Since
That-
2012, they are not separate,
They are
residing.
together because at that, it was in 2012 that the FIR was filed by her first, alleging 498A IPC.
So since 2012, she is staying at Bongaigaon.
Yes.
At Bongaigaon.
Okay, what is your case?
And the petitioner, one last
Let me
submission, your
finish.
lordship, one last submission. And admittedly, the respondent, your lordship, he is a service holder. He is residing at Pune, not even at Tezpur, your lordship. So either ways, if it is to be decided by honorable district judge, either at Tezpur or at Bongaigaon, he will have representation through an advocate. And since he is not a regular resident of Tejpur as well, so transferring the case from Tejpur to Bongaigaon will have no effect on his convenience, Your Lordship. Just one case case law that I would like to rely on. 2022 6 SCR 1085. NCV Aishwarya versus AS Ravana Kartik Shah at para 9, Your Lordship. At page 1087. If I may read, Your Lordship. The cardinal principle for exercise of power under section 24 of the Code of Civil Procedure is that the ends of justice should demand the transfer of the suit, appeal, or the other proceeding. In matrimonial matters, wherever the courts are called upon to consider the plea of transfer, the courts have to take into consideration the economic soundness of both the parties, social strata of the spouses, and their behavioral pattern, their standard of life prior to marriage and subsequent thereto, and the circumstances of both the parties in carrying out their livelihood and under whose protective umbrella they are seeking their sustenance to life. Given the prevailing socio-economic paradigm of the Indian society, generally it is the wife's convenience which must be looked at while considering transfer. So in this case, I have submitted that the maintenance, Your Lordship, is not being paid, 1,500 per month, and
Yes.
now they are praying for objecting to the transfer to the law.
My lord, the criminal cases have been annexed only to make out the conduct, the issue of conduct, because my lord, as many as 3 or 4 cases have been filed serially one after the other. If your lordship will kindly have, my lord's page 72 of my affidavit. This was the case, my lord, 498A IPC. This was decided by the Honorable Additional Session Judge, my lord, at Tezpur. And in this case, my lord, the family members and the petitioner herself appeared as a witness. If your lordship will kindly have, lordship has page 72. my lord.
Yes.
Lordship will have para 28 onwards. If I may read.
No, what you want to show?
My lord, I want to show that, my lord, all these proceedings, my lord, and including this transfer petition is nothing but, my lord, to harass me and nothing. The end. My lord, the 498A IPC was, my lord, I was acquitted. She and all her family members have appeared in the case at Tezpur. In fact, they had hired their own lawyer, engaged their own lawyer also before the Additional Session Judge. Lordship will find at the page 54, my lord, the list of accused and the list of witnesses is also there, which is at, my lord, page 75. Your lordship finds, my lord, page 75, there is, my lord, the PW7, that is the petitioner, Ashalata Baisho, PW8, Gopal Baisho, Rakhal Baisho. These are father, brother, they all appeared as witnesses. And these proceedings continued in the learned court at Tezpur for almost 12 years. From 2012, when it started, until 2024, when I was finally acquitted. This is the first part. Now, my lord, secondly, the case that was filed by her at Bongaigaon, lordship will find at page 78. Page 78, my lord, this was filed under 406 and other sections, my lord, for Sridhan, etc. Here also, my lord, we were acquitted, giving the benefit of doubt. And the specific observation is that the complainant has failed in proving the charges under section 406, 506, 34 IPC against the accused persons beyond all reasonable doubt. Hence, the accused are given benefit of doubt and are acquitted. Then, my lords, the fact remains that at page 80, your lordship will find that already, my lord, the petitioner has appeared in the learned trial court where the divorce petition has been filed by engaging a lawyer. Now, my lord, the fact remains that this is not a proceeding under the Family Courts Act. The embargo under section 13 of the Family Courts Act, where she will be required to go daily, that is not, my lord, required in the present case. So since she has already engaged a lawyer who has filed petitions on her behalf, what prevents her from filing the written statement? In fact, my lord, I have specifically stated in my objection that I am ready to defray the expenses as may be directed by the learned trial court. In this regard, I would like to place but two judgments of the coordinate bench, my lords, where this embargo has been noted. The fact that in a matter of transfer, it is the burden, my lords, of the petitioner to explain why the transfer should be, my lord, done. And in a case where, my lord, the embargo under section 13 of the Family Courts Act is not applicable, your lordship will kindly have, the lordship may have the transfer petition 22 of 24. Both are reported, my lord, but I cannot find the citations. Now, if your lordship will come to para 10, my lords, internal page 4.
Yes.
Have it, my lord? Lords, para 10. It has been admitted at the bar that there is no family court established in terms with section 3 of the Family Court Act so and so in the district of Tezpur. And the divorce proceedings under the Hindu Marriage Act 1955 is taken up by the court of the district judge Sohitpur at Tezpur. Under such circumstances, it has been submitted that the embargo under section 13 of the Family Courts Act, which stipulates the mandatory necessity of the appearance of the parties before the family court, is not applicable to the matrimonial proceedings before the learned district judge Sohitpur at Tezpur. In the backdrop of the said submission, this court therefore needs to take into consideration as to what inconvenience would be caused to the parties if the matrimonial proceedings are allowed to be continued before the court of the learned district judge Sonitpur at Tezpur. As the embargo which is being imposed under section 13 of the Family Courts Act is not applicable before the court of the learned district judge at Sonitpur at Tezpur, the petitioner can very well participate in the said proceedings through a legal practitioner, and it is not required for her to appear on each and every date, save and except when directed by the court wherein the said divorce proceedings are pending. Next para, taking into consideration that the code of civil procedure is applicable and it is only at the stage of cross-examination when the witnesses who adduce the evidence on affidavit are required to appear in the court or before the commissioners who appointed, or for that matter when the court directs personal appearance of the parties. The appearance of the parties are required. This court is of the opinion that no inconvenience would be caused if the proceedings are allowed to be continued before the court of the learned district judge Sonitpur at Tezpur. However, in order to meet the interest of justice and taking into consideration that the petitioner has no independent source of income as alleged except to ask her parents, this court is of the opinion and accordingly directs that whenever the petitioner's appearance is required before the court of the learned district judge Sonitpur at Tezpur, the respondent shall deposit an amount of rupees 3,500 before the court of the learned district judge Sonitpur at Tezpur, and the petitioner upon her appearance before the said court on the said date shall withdraw the said amount with the permission of the court of the learned district judge Sonitpur at Tezpur. In view of the above, this court is therefore not inclined to transfer the title suit number so and so.
You are ready to pay,
Yes, my lord. I have specifically stated.
but you have not paid the maintenance.
That is an allegation that is made today, my lord, in first time in the submissions. Regarding that, I have no, but if your lordship passes a judicial order directing the learned trial court to pay 3,000.
The payment of maintenance is also a judicial order.
Even under section 24 of the HMA, my lords, I have to pay the litigation, the pendental IT expenses, man. Those expenses I have to pay. Now, if the learned trial court passes a judicial order following your lordship's order for payment, I am bound to pay. I cannot violate such an order. And in fact, my lord, that is why, my lord, in the second case, my lords, also similar orders have been passed. So, my lord, when the court is cognizant that section 13, which is only applicable at present to the family courts at Kamrup Metro in Guwahati, my lords, and in a case where she has already engaged a lawyer who is appearing and who has filed petitions on her behalf. But considering that I also, my lord, have to come from Pune, whether at Tezpur or at Bongaigaon. Bongaigaon will make it more difficult for me. Tezpur, at least it is my home district. So considering the convenience, I am ready to reimburse. I have specifically stated, my lord, will find that statement that I have made, which is in para 13, my lord. Page 50.
Okay.
Lord.
Why have you annexed Annexure C at page 79? Whose document is this?
Yes, sir. This is that maintenance regarding this.
No, what is your submission as regards this?
Submission is only this, my lord, that the maintenance case which was there at Bongaigaon is now complete. It is over. So now there is nothing, no case pending at Bongaigaon which I would have to personally perhaps attend or even through a lawyer. So now the live proceeding that is there is at Tezpur. And only for the reason that perhaps inadvertently or whatever, I do not know, my lord, but the order, if your lordship finds, is written, whereas an order has been passed against you on dated 20/10/2014 to pay monthly maintenance to the first party along with her 2 children amounting to 1,500 per month. And in any case, my lord, he is a service holder. He is working as a cook in the GREF. Even his, my lord, salary can be attached. The learned trial court so desires.
heard Mr. B. J. Mukherjee, learned counsel for the petitioner. Also heard Mr. A. Ganguly, learned counsel for the respondent. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner, namely Srimati Ashalata Mitra Bushra, alias Ashalata Bushra, for transfer of title suit within bracket M case number title suit M number 124/2024, which is a divorce proceeding pending before the Court of Learned District Justice to the Court of any competent to any competent court having jurisdiction at Bongaigaon. Learned counsel for the petitioner has submitted that the petitioner was married to the respondent on 8/3/2012 at Bongaigaon as per Hindu rites, and thereafter they started living as husband and wife in the matrimonial home of the petitioner at Tejpur. Stop, next para. It is further stated by the learned counsel, it is further submitted by learned counsel for the petitioner that matrimonial discord erupted between the parties, and the petitioner was forced to go back to her paternal home at Bongaigaon in the year 2012. Learned counsel for the petitioner further submits that the petitioner had filed criminal cases against the respondent under section 498A of IPC at Tejpur, in which the respondent was acquitted by the trial court. He further submits that thereafter the petitioner had filed cases under Section 12 of the Protection of Women from Domestic Violence Act, as well as case under Section 125 of CRPC claiming maintenance. Stop. He submits that in the proceeding under Section 125 CRPC, the respondent was directed to pay a maintenance amount allowance of maintenance amount of rupees 1,500 per month. However, the respondent has not paid any money against the said maintenance amount. Stop. It is further submitted that the outstanding due against the area maintenance amount allowance has become rupees 1,59,000. And in spite of the receipt of notice by the respondent he has not paid the maintenance allowance to the petitioner. Learned counsel for the petitioner submits that the respondent has filed the divorce proceeding in the Court of Learned District Judge H4, which has been registered as title suit within bracket M number 124/2024. In spite of knowing that the petitioner was residing at Bongaigaon since the year 2012, he submits that petitioner, being an unemployed woman and she is facing financial problem, more so when the maintenance allowance, which was directed to be paid to the petitioner by the respondent, has not yet been paid by the respondent. He submits that the petitioner is dependent on her parent. Who is there?
Parents, both the parents.
Parents.
At para 11 as stated.
And
Father is active.
aged parent and has no independent source of income. He further submits that under such financial constraint, it would be difficult on the part of the petitioner to pursue the divorce case by engaging a counsel and going to Tejpur to do so. He further submits that on the other hand, the respondent who had filed the divorce case in Tejpur himself does not reside at Tejpur. He is presently working at Pune. And for him, it would not be difficult to attend. And it is submitted that for the respondent, it may not be difficult to attend the courts at Bongaigaon. As for him, it would be same to attend the court at Bongaigaon or at Sonitpur. Stop. Any other submission? The learned counsel for the petitioner has further submitted that while deciding an application for transfer of matrimonial dispute from one court to another, the prime consideration is the economic soundness of both the parties and social strata of the spouses and their behavioral pattern. He submits that the apex court in a catena of cases has observed that in the prevailing socio-economic paradigm in the Indian society, generally it is the wife convenience which must be looked at while considering an application for transfer. In support of his submission, he has cited a ruling of the apex court in the case of NCV Aishwarya versus AS Sarvana Karthik SHA, reported in 2022, 6 SCR 1085. So, on the other hand, Mr. A. Ganguly, learned counsel for the respondent, has vehemently opposed the prayer for transfer of aforesaid case from from the court of District Judge Tejpur, District Judge Sonitpur, to any other court in Bongaigaon. He submits that this instant transfer application has been filed by the petitioner only with a mala fide intention to harass the respondent. He further submits that prior to this, the petitioner had filed criminal cases not only against the petitioner but also against his other family members, wherein he has been acquitted by the trial court. He further submits that the divorce case, transfer of which is sought by the petitioner, is filed in the court of District Judge Sonitpur and not in the family court, as Sonitpur does not have any family court. He submits that as such, the embargo of Section 13 of the Family Courts Act is not applicable to the case, and it is not mandatory for the petitioner to personally appear before the family court, and she can very well pursue her case by engaging a counsel.
She is already engaged the counsel.
He further submits that in the divorce suit which is sought to be transferred, the petitioner has already engaged a counsel, and as the necessity of personal appearance is minimal on only those days where court directs to do so, there would not be much inconvenience on the part of the petitioner to attend and pursue her case in Sonitpur. He further submits that the petitioner is even ready to pay the conveyance expenses incurred by the petitioner in attending the courts at Sonitpur in the aforesaid divorce proceeding. And as such, he prays for dismissing the present transfer application.
Small submission, my lord. The judgment cited by my learned friend regarding transfer from one family court to another.
Stop. He further submits that the judgment relied upon by the learned counsel for the petition, judgment cited by the learned counsel for the petitioner is distinguishable from the facts of this case. No, line continue. The facts of the case cited by the petitioner, learned counsel for the petitioner, is distinguishable from the facts of the instant case, in as much as in the case cited by the learned counsel for the petitioner, the transfer was sought for from one family court to other family court, and as already submitted by him, the embargo of Section 13 would have been applicable in those cases, which is not applicable in the instant case. Hence, he prays for dismissal of the instant transfer application. I have considered the submissions made by learned counsel for the both sides and have gone through the materials available on record, including the rulings cited by learned counsel for both sides. When is the next date? When is the next date before the trial court?
Statement. Has been stayed by this one. by order dated 11/9/2024, my lord, this court had stayed the proceeding. Perhaps there may not be any fixed date.
I am reserving the judgment. Wait for. Baकी to reserve. CB. This one.
It is a part-heard matter, my lord. Lordship has always had the matter. And your lordship has, asking you to file written argument. This second appeal arises out of a concurring judgment, my lord, by which both the courts below had dismissed the plaintiff suit for declaration of title, confirmation of possession.
You have prepared written submission. You have also.
No, lordship. On last occasion, my learned friend has submitted that she will argue orally and thereafter written argument will submit.
Okay.
So I'll submit from the records, lordship.
The RSA is yet to be admitted.
Yes.
So the question is whether substantial question of law is involved or not. Whether at the stage of admission, you have a right to be heard.
I have filed caveat. If I filed a caveat, then I have a right. I have a decision on that point.
Okay, okay.
Lordship.
Yes.
Plaintiff suit was dismissed. Plaintiff suit for dismissed for declaration of title, confirmation of possession, and declaration of sale deed as void and permanent injunction. And the defendant's title was declared on the basis of mutation and patta and long possession. The facts of the case is that my father.
There was a counterclaim also.
Counterclaim. So counterclaim is also dismissed, that therefore we have filed 2 appeals now. Counterclaim was decreased, sorry, dismissed, decreased, that's it.
Okay. And plaintiff suit was decreed on what basis?
I am the plaintiff, my lord.
Your suit was dismissed.
Dismissed.
Counterclaim was also dismissed.
Counterclaim was decreed, my lord.
Decreed. Okay. Decreed on what basis?
Because they're on the basis of mutation and patta and long possession.
Okay. Now, what is your submission?
My lord, I have filed an additional amendment memo paper where I stated the proposed substantial question of.
Where?
Filed an additional.
Additional affidavit.
Additional, sorry, amendment of memo paper, my lord. Amended memo paper. I've seen it is on the record.
Page number?
4, my lord.
Yes.
Yes, my lord, both the learned courts below have declared that that the plaintiff has no right title interest over the suitlet on the basis of the gift deed will.
On the basis of the?
Basis of the gift deed executed by my father, as my father has no authority to give the land, because my father has gifted 28 bighas of land, which includes my mother's land 4 bighas. and the suit land is forms a part of 4 bigha, my lord. Therefore, both the learned courts below declared that my father has no right to give the said property, but the defendants in their written statement in earlier suit is also admitted, I have no right on the basis of the gift deed, but by inheritance, I inherited the suit property. By the right of inheritance, I got the suit property, my lord. So, but that finding is not given, my lord. That I'm entitled to get the suit property on the basis of inheritance. The learned court below said that through gift deed, I am not entitled to get the suit property, my lord.
Which is the substantial question of law?
And number one,
One is not substantial question.
number two, on the basis of declaring title of the defendant over the suit land on the basis of the entry made in the revenue record, my lord. And another holding that the suit of the plaintiff is barred by law of limitation. The land, both the court below stated from the day mutation was made before 22 years, and I have filed the suit much later. Therefore, my suit is barred by limitation. But I have filed the suit when my possession was threatened, my lord. And from the date of threatening, my suit is within limitation, my lord. There is our High Court judgment is also in this regard, my lord. Privy Council judgment, my lord, I have given, my lord. Bolo versus Cochran. In page number 331. Your lordship got it.
No. The trial court as well as first appellate court held that the suit is barred by limitations. How they are wrong?
They said that I have filed the suit much later. The suit has to be filed within 3 years from the date of mutation, my lord. From the
Have you prayed for cancellation of mutation
no, my lord. I have
or recovery of possession only?
no, I have filed confirmation, but I am in possession, my lord. I paid for declaration of my title because my title was threatened, my lord. That's it.
No, what is your submission? That law is that the limitation is to be counted from
From the
the
date
date when your possession
there was
get written.
one judgment, my lord, that is I have given, my lord. Bolo versus Cochran, my lord. Where it is a suit for which there can be no right to sue until there is a accrual of the right asserted in the suit and it is infringement or at least a clear and unequivocal threat to infringe that right by the defendant against whom the suit is instituted. Another judgment I have given of this Honorable High Court, my lord, Harendra Chandra Nath versus Vijay Krishna Nath.
Okay.
Another substantial question we have raised, my lord, may I give the same that whether the learned trial court held that my suit is barred by section 34 of the proviso of 34 of Pacific Relief Act, my lord. That I have raised, my lord. May I submit?
What is proviso to section 34?
Further relief, consecution relief, I have not
Not paid for
paid
consecutive.
for. But I have said I have in possession. And therefore I filed the suit for declaration of title and confirmation of possession and permanent injunction. And both the courts, there is no finding in respect of this possession. My possession, defendant's possession was declared on the basis of mutation, my lord. And that the appellate court was also that long possession gives them a title, but no adverse possession has been pleaded.
Why court made such observation? Because you failed to challenge the mutation order.
I have did not paid for cash possession, recovery of cash possession.
No, you are saying that you have prayed for confirmation.
That since the dependent are in possession, therefore I have to pray for recovery of possession. That
Now, who is in position?
I am in possession, my lord. And there is no, both the courts did not give any finding regarding dispossession. Their possession is declared only on the basis of mutation, my lord.
Where is that observation, that section, proviso to section 34? In the trial court, in which court's judgment appeal?
Sixth trial court, lordship, paragraph 15.
Para
15.
1-5. No, that is what I am asking. That court held that you failed to pray for cancellation of patta. That consequential relief you have not prayed for.
Patta is issued by an administrative authority, my lord. Therefore, cancellation of patta, since I have paid for declaration of my title. Therefore, I approach the civil court. Civil court will declare my title.
Okay.
The defendant's case is that they entered into the possession of the suitlet on the basis of the oral sale mill. And the learned court will held that oral sale is not permitted as per section 54 of the Transfer of Property Act, my lord. Since the entry is wrong, how can be the mutation and patta will give the title to the defendant mill?
So these three substantial question of law you are proposing. Anything else? Yes.
In this case, what happened was the plaintiff and defendant number 2 are brothers. Lordship. They both are brothers. Plaintiff is the owner of the suit property and he was in need of some money, lordship. The defendant number 2 helped him by giving 6,000 rupees, lordship. After that, there is a family settlement and all the brothers advised plaintiff to register the land in the name of the defendant number 2. Thereafter, plaintiff went to the revenue authority and relinquished his title, lordship, before the revenue authority. Thereafter, my name was recorded, defendant number 2's name. Then defendant number 2 sold out the said land in favor of defendant number 1 by a registered deed. So there are some issues which were formulated by the learned trial court. Whether the suit is maintainable, whether the suit is barred by law, whether the suit is barred by limitation, whether the suit is bad for non-joinder of necessary parties, and whether the plaintiff has cause of action, whether the plaintiff has right title interest over the suit land by virtue of gift deed. Plaintiff's case is that this is his gifted property by his father, and including the mother's land also. So both the courts held that as mother's land cannot be gifted by father, so that plaintiff is unable to prove his gift deed, entitlement of right title interest through gift deed. But plaintiff is owner of the suit land, it is admitted by the defendant. Because from him only we are claiming our ownership, lordship. Thereafter, one issue, lordship, whether the registered sale deed number 6.
How the ownership was
He
conveyed.
relinquished his share, Lordship.
Any proof is there in the,
PW
so,
himself admitted that since 1991, the revenue records were corrected in favor of the defendant number 2. And there is a clause in revenue. There is a process, Lordship, in Assam Land and Revenue Regulation 1886, forfeiture of landholder rights on relinquishment.
which provision?
That is, Lordship, Chapter 2, Rights over Land, page 38. Regulation 10, Lordship. Forfeiture of or landholder's right on relinquishment. Any landholder who, after the commencement of this regulation, voluntarily relinquishes any land and ceases to pay the revenue excess thereon shall at once forfeit his status of landholder in respect of that land. So the defendant number 2's case is that plaintiff went along with him to the revenue authority, relinquished his right, and thereafter revenue authority issued patta in favor of the defendant number 2. Thereafter, after long possession, on the basis of his long possession, adverse possession, Lordship, as well as by issuing, on the basis of issuance of patta, the defendant number 2 perfected his title, Lordship. So defendant number 2's title was considered by both the courts below. They have enclosed the statement of PW1, Lordship. There is an additional affidavit, page 7. Lordship. PW1, he himself admitted that, page 117 of additional affidavit, it is a fact that the suit land has got mutated in the name of defendant number 2 in the year 1991. I know English calendar years and now this year is 2016. I filed application for shifting out the name of defendant number 1 from the mutation record before Sri Jangam Circle. There was no hearing took place after filing of the application by me. I have not submitted the copy of the aforesaid application in this suit or have not applied for calling of the same. It is not a fact that I have not submitted any application before the circle officer of Sri Jangam. I have not filed any appeal before the Deputy Commissioner Bongaigaon for correction of mutation records. It is not a fact that I have not prayed for cancellation of patta in the name of defendant number 2 among the prayers of paragraph number 19 of my plaint. It is a fact that I have claimed that 4 bigha of land out of Schedule A land was in the name of my mother, Sukhjan Nessa. It is also a fact out of the aforesaid 4 bigha of land, I claim for 1 bigha 1 katha 9 nesa by suit, and the patta of the aforesaid land is 141 situated at part 2. I do not know if the aforesaid 4 bigha of land is not described in the plain. Then, Lordship, take further cross-examination, March 2016, the defendant has come to our land and tried to physically abuse us, and the said day is 2/9/13, and the opposite party has thereafter never came to our land to beat me. I do not know whether the case record mentioned in paragraph number 13 was called or not in the case. So basically, Lordship, he admitted that it is within his knowledge since 1991, defendant number 2 is possessing the suit land. And before that also he admitted that
Now in whose possession suit land is?
in our possession, Lordship.
In your possession?
Yes, Lordship. On last occasion, I stated that possession was taken by plaintiff, but thereafter I have taken information that since 2024, Lordship, they have cultivated the land. And now the children.
Last occasion,
I
you
have
submit
mentioned
that by beating of drums.
Lordship, for permanent injunction. Execution was filed for Lordship, execution of the order of injunction by beating drum.
Okay, okay. Have you got the copy of the written argument submitted by?
No, Lordship.
You have a copy for her also? No, what is your response to?
The courts held that, Lordship, the patta was issued in favor of the defendant long back. They never prayed for cancellation of that patta, Lordship. So the suit is barred by Section 34 of the Specific Relief Act as well as by limitation, Lordship. And the right title of the plaintiff was not declared on the basis of gift deed, but it was not held by both the courts that plaintiff has no right title interest. That was not had. So the first substantial question of law is not applicable, Lordship. That whether the learned trial court as well as appellate court were correct in holding that the plaintiff has no right title interest over the suit land. But in fact, both the courts held that plaintiff has no right title interest on the suit land on the basis of gift deed. And whether the learned courts below are justified in declaring the title of the defendant number 2 over the suit land on the basis of the entry made in the revenue record in complete disregard to the established principle of the law that such entry is not conclusive proof of title. As in this instant case, Lordship, there was no registered sale deed. Only by relinquishing his right, he has transferred the right title interest to defendant number 2. So only on the basis of mutation record, the defendant number 2 is claiming right title interest, as well as adverse possession, Lordship. That was also there in the pleading in the written statement. So both the courts are correct in declaring right title interest of the defendant number 2 on the basis of mutation record as well as adverse possession. So there is no perversity. If there is any perversity, Lordship, then only this substantial question of law will arise, Lordship. Then the fourth substantial question of law, whether the learned courts below were justified in holding that the suit of the plaintiff is barred by law of limitation. Both the courts decided that issue, saying that the plaintiff is aware about the recording of name of the defendant number 2 in the revenue record since the date of recording his name. So the filing of the suit in the year 2013 is barred by limitation.
No, her submission is that she
Apprehension.
approached the court only when she was threatened by you for disposition.
Lordship.
As because her suit was for confirmation of possession.
Lordship, page 58 for a moment, Lordship. Moreover, finding the continuous and long possession of the defendant number 2, the Revenue Authority issued Exhibit B, that is mutation certificate dated 12/7/2010 to the defendant number 2. Paragraph 19, as per section 41(2) of the Assam Land and Revenue Regulation 1886, record of rights made under the said provision is to be presumed as correct until contrary is proved, and the plaintiff has failed to rebut the presumption. As Exhibit A is issued in favor of defendant number 2 on the basis of his long possession over the suit land without any objection from any corner. Therefore, defendant number 2 is found to be the right title interest and possession holder of the suit land. Exhibit A is the patta, Lordship. Further, this instant suit is filed after 22 years of taking possession over the suit land by the defendant number 2, and in the meantime, patta in respect of the suit land is also issued in favor of the defendant number 2. Accordingly, the suit of the plaintiff is hopelessly barred by limitation under Article 64 of the Limitation Act. And the evidence of the DW1, Lordship, remain untouched as because the plaintiff failed to cross-examine the DW1, Lordship. And his own witness PW3 never came to adduce his evidence, Lordship, so PW3 was not taken into consideration. Paragraph 21, Lordship, the DW1 deposed that the suit land is sold to him by the defendant number 2 by registered sale deed number so-and-so, dated 23/4/2013. He proved the sale deed as Exhibit D. The sale was executed followed by delivery of possession, and the plaintiff has not denied the execution of said sale deed. Hence, from consideration of the evidence, I am of the opinion that defendant number 2, being the title holder having transferable right over the suit land, legally and validly transferred his right title interest and possession over the suit land to the defendant number 1. So there is no perversity, Lordship. Moreover, they have taken a stand that there is a pendency of another title suit 71 of 2010. So there is an issue framed that whether during the pendency of title suit 71 2010, the registered sale deed which was executed is a valid deed or not. Paragraph 22, Lordship, page 59. The plaintiff has challenged exhibit D because during pendency of title suit number so and so, the plaintiff of that suit, now defendant number 2, with view to defeat the defendant now plaintiff, made collusion with defendant number 1 secretly and without the knowledge of the present plaintiff, and executed registered sale deed number so and so. Hence, alleged that the sale deed is illegal and void. PW1 during cross-examination deposed that he could not say whether he called the case record of title suit number so and so in this suit or not. He could not say whether he submitted the certified copy of the said suit in this suit or not. The said suit is presently dismissed. He could not say on which date the said suit was dismissed. In this present suit, the plaintiff neither called for the title suit number so and so nor proved any certified copies of order sheets of the said suit. The plaintiff admitted that suit is dismissed, but he could not say about the date of dismissal. Hence, upon consideration of the entire facts, it reveals that plaintiff has even failed to prove that exhibit D was executed during the pendency of title suit number so and so.
Okay.
So there was no effort, no evidence from the plaintiff, lordship. Only on the basis of PW 1 and 2, the plaintiff contested the suit, lordship. They even did not cross-examine the DW 1, only one witness from the defendant side. So accordingly, the counterclaim was declared and decreed and suit was dismissed, lordship.
Okay.
Relinquishment was not proved, my lord, by calling the revenue officials. Although they pleaded that the relinquishment was made, but relinquishment was not proved. Secondly, my lord, adverse quotation has not been specifically pleaded, my lord, in the written statement. And thirdly, my lord, in my claim as well as written statement against the counter claim, I said that the patta and mutation was issued without my knowledge, my lord. And the cross-examination, it is only an assertion of facts made by the defendant in the written statement. It is not an admission, my lord, because there is no suggestion in the cross-examination whether you have the knowledge or not. It is only an assertion of facts made by the defendant in the written statement. It is not an admission, my lord.
What have you stated in cross-examination? When you came to know about? When you come to know about the mutation?
When my, in the year 2013, my lord. When
When your position was threatened? Heard, Miss Isra.
This page 117, lordship, it is admitted that it is a fact that the suit land has got mutated in the name of defendant number 2 in the year 1991. So there is an admission, lordship.
Page
117 of the additional affidavit, lordship.
Moreover, even if I know, in the trial, both the courts below give title on the basis of mutation and patta. There is a Supreme Court as well as our Honorable High Court decision was also there, my lord. And it is not necessary to file a suit immediately. When my possession was disturbed, then my right to sue from, my lord.
In page 117, where it is mentioned?
It is a fact that. Third paragraph, lordship.
This is the testimony of PW1, okay.
PW1, lordship. So PW1 admitted that it is a fact that his name was recorded in the year 1991. So it is within his knowledge.
It is a fact, but there is no such.
Now, any execution proceeding is pending.
Yes, lordship. They have enclosed the documents, lordship.
You have filed execution pay.
Yes.
But you are saying that the suit property is in your possession.
Yes.
Then why execution?
For execution of the permanent injunction by beating drum in the local lordship.
My lord, trial court as well as the court in earlier suit granted temporary injunction in favor of me. And in page number 117, it is a fact, but there is no suggestion when you come to know. Therefore, it does not mean that the plaintiff have the knowledge that suit land was mutated in the year 1991.
Okay. Heard Mrs. Roy. Learned counsel for the appellant. Also heard Miss R. Chaudhary. Learned counsel for this, all the respondents.
Yes.
Learned counsel for the caveators slash respondent. The learned counsel for the appellant has filed an amended memo of appeal. Stop. She has also filed a written argument, written gist of her submissions. Heard, no, written gist of her submissions. Both the council, learned councils were heard under Order 41, Rule 11, as to whether substantial question of law may be formulated in this appeal and not whether notice has to be issued or not. Let this case be listed for delivery of orders on 30.
May I submit that judgment to caveators right, Lordship?
No, that I agree. But you can give a judgment.
Lordship, that on power of section 100, Lordship, I'm citing two judgments.
That caveator,
Caveator is, Lordship, that is Madhav Govind Garg. Paragraph 46, Lordship.
what it says,
It directly said that on the prayer of interim prayer, Lordship.
no, my query is under Order 41, Rule 11,
Yes, Lordship.
whether other side has a right to be heard
Lordship,
before
advertising
issuing
facts
notice.
of the present case as already noticed, the appellants had also filed caveat in the appeal. In law, the rights of a caveator are different from that of cross-objectors per se. In terms of section 148A of the code, a caveator has a right to be heard mandatorily for the purpose of passing of an interlocutory order. The law contemplates that a caveator is to be heard by the court before any interim order can be passed against him. But in the present case, when the appeal was listed for hearing at the admission stage itself, the appellants had appeared and argued the matter not in relation to grant of an interim order, but also on the merits of the appeal. So, Lordship, caveator has a right to argue at the admission stage, Lordship.
Against passing of an interim order.
Lordship. Your
Okay, you
Lordship.
give that judgment to me.
Lordship. And on power of 100, Lordship, I am citing two decisions from Honorable Supreme Court, Lordship, paragraph 50. Para 14, power of High Court under section 100, Lordship, and para 22 to 32, power of High Court under section 100. One is Jaisan and one is State of Rajasthan and others. Lordship.
You mentioned paragraph number.
Lordship.
Okay, on 30 January.
30, Lordship, can it be on 31, any other date? Any other date, Lord? 31st? 29 or?
29.
Lordship.
29.
Oblige.
Respondent or lawyer যেহেতু judgment দিব respondent বলে লিখে দিব ইহতে লিখে দেব
Order 120.
But this honorable court has directed me to take steps upon respondent number 8, my lord, which I have taken earlier, my lord. And as per office note dated 9/1/2026, my lord, the said notice has been properly served upon the respondent number 8, my lord. Office note dated 9/1/2026, my lord.
And as against other respondents?
Other respondents, my lord, as per office note dated 6/3/2024, respondent number 2, 3, 4, 5, and 6 already entered appearance, my lord. AD card in respect of respondent number 7, 9 Roman 1, 9 Roman 2, and 10 received back, but they have not entered appearance, my lord. And my lord, unserved notice in respect of respondent number 1 received back with note addressee expired, my lord. Here, my lord, respondent number 1 or the legal years of respondent number 1 already on record, my lord. The respondent number 2, 3, 4, 5, and 6. They are the legal years of respondent number 1, my lord.
What for this IAs?
IA is for, my lord, delay condonation petition, my lord. 503 days delay, my lord.
Okay. Heard Mr. M.K. Sharma, learned counsel for the applicant. On perusal of the office note dated 9/1/2026, it appears that the service report in respect of notice issued to respondent number 8 has returned, and it has been reported that the notices have been served personally on the said respondent. In view of the aforesaid report, the notice issued to respondent number 8 is held to be duly served on the said respondent. As regards respondent number 1,
The legal years already on record, my lord. They are respondent number 2, 3, 4, 5, and 6, my lord. So no separate substitution petition is necessary.
okay, learned counsel for the applicant has submitted that though the respondent number 1 has expired, however, the legal years of respondent number 1 are already implemented in this case as respondent number 2, 3, 4, and 5, 5 and 6. And notice issued to them have, where is the,
My lord, office note dated 3/6/2024, my lord. They have already entered appearance, my lord, through their engaged counsel, my lord.
in the,
My lord, I am sorry, my lord, 2, 3, 4, and 5, my lord, they are the legal years of respondent number 1.
2, 3, 4, and 5.
Office note dated 3/6/2024, my lord.
In this IA,
Yes, my lord. And in fact, my lord, the name of the counsel for representing the said respondents already reflected in the cause list.
have been duly served on them, and same has been reflected in the office note dated 6/3/2024. In view of the aforesaid office note as well as submissions made by learned counsel for the applicant, it appears that the notice on all respondents are duly served. We'll give one date. Let this matter be listed for in orders column on for hearing on delay condonation application on 12th of February.
Deeply. May I please your lordship? Lordship, as per the last order, lordship, we have taken the steps on 26/9/25 upon respondent number 1A to 1B. But lordship, the office note shows that the respondent number 1A and 1E has expired, lordship.
Oh,
So lordship, some time may be given to file the substitution petition, lordship.
okay.
Find out the legal.
What is your name?
SN Ahmed, lordship.
S.N.
Ahmed.
Heard Mr. S.N. Ahmed, learned counsel for the applicant. Also heard Miss P. Bhattacharjee, appearing for
2 and 3.
respondent number 2 and 3. Who is appearing for 1?
That is the substitution.
Oh,
petition.
yes, 2 and 3. 2 and 3. Learned counsel for the petitioner applicant has submitted that which office note says that yes, they are having
Lordship, office note dated 6/1/26, lordship.
One A.
1A.
no such office note is there. Mathur. AC to give. क्या लिखा? Submitted that the office note dated 6/1/2026 shows that the respondent number 1 within bracket small a and 1 within bracket small e have expired, and as such he seeks some time for taking appropriate steps for substituting the legal heirs of the said respondent. The learned counsel for the other respondents have not objected to the said prayer, as the prayer is allowed. List this matter after 4 weeks. Oh.
Application for condemnation of delay of 4,792 days plus filing the appeal.
4,000?
792 days plus.
You have filed any objection?
Yes.
It's a huge delay.
Delay is all explained, lordship.
Okay. In filing the land acquisition appeal,
Appeal, lordship. What has happened? They have filed a reference case. In the reference case, we are not made party. Only the collector was made party. We were unaware. Then execution was filed. In the execution, we were served with a notice by the collector to deposit the enhanced amount.
who are you?
I am the recurring department. lordship.
Indian Oil.
Indian Oil Corporation.
Okay.
What has happened in the year 1996, 63 bighas of land was acquired. And the collector assessed the award as 16,000 per bigha. Thereafter, they have filed a reference case wherein IOCL was not made in party. In the reference case, the compensation was enhanced from 16,000 to 70,000 per katha. lordship. Then we were unaware of that. Suddenly in 2022, they filed, an execution case was filed. Then Deputy Commissioner issued a letter asking us to pay that amount, enhanced amount. Thereafter, we applied for certified copy in the executing court. Executing court said that the record is not with us. Then we applied before the concerned court, but we did not receive the certified copy. That is why all delay has been caused. We have also given a complaint to the district judge for non receipt of the certified copy. Then we have filed this application
When you came to know about the,
in the year 22, Lordship.
where is that statement?
Yes. Lordship may come to paragraph 5. That the applicant states that by letter dated 1/4/22, the Deputy Commissioner Kamrup Metro has informed the applicant that money acquisition case number 7/2020 in respect of judgment dated so and so is pending and requested the applicant to deposit the decretal amount which was quantified as 58,34,131 in respect of this. Thereafter, we applied for certified copy. But certified copy we did not receive.
When you came to know on 1/4/2022, that was the date of the letter.
Upon receipt of on 4/4/22. We have received the letter on 4/4/22.
Okay. Thereafter,
Thereafter, we had applied for certified copy, Lordship. We had issued a letter to the reply to the letter of the Deputy Commissioner, Lordship. Then for asking for furnishing the relevant documents for filing the appeal. We have also sought for the certified copy of the order, but we didn't receive. Subsequently, in July, we have applied for certified copy, Lordship. And certified copy, we applied in the executing court. Executing court told us that record is not with us. You may go to the trial court where reference court. Then we, in December 2022, we have applied the certified copy in the reference court, Lordship. But till date, we could not receive. We visited various time, Lordship. And we have raised a complaint on 27/2/23, apprising the district judge that we have not received the certified copy. That's also annexed, Lordship. Lordship may kindly come to page 26, Lordship. That is why all delay has occurred.
when you received the certified copy,
We have
ultimately,
not received the certified copy.
It is annexed, Lordship.
No, there is from the records of the executing court, Lordship. We have got it. Copy furnished by the Deputy Commissioner. All these copies are furnished by them. But we could not get all of the certified copy because we're filing an appeal, we need the original certified copy, Lordship.
May Lordship. Lordship may kindly come to page number 36, Lordship.
page number 30.
Page number 36, Lordship. This is a letter, Lordship, sent by Additional Deputy Commissioner to the government leader, Lordship, on 7/10/2010, Lordship. Regarding the case, reference case, Lordship. And dear Lordship, copy was forwarded to the area manager IOC Assam Marketing Division, Lordship, which they have received on the very next day, Lordship. That is page number 38, Lordship, respect of the peon book, Lordship, of this year. So it is not true that they have the knowledge in 2022, Lordship. They had the knowledge of pendency about the reference case in 2010.
What is page number 38?
Page number 38, last one, Lordship. Area manager IOC, he has received the letter, Lordship.
No, what is this 38?
It is abstract of beyond DC office.
Of DC.
Yes, Deputy Commissioner's office.
This affidavit has been filed by the private husband or Lordship.
And that is acknowledged by them, receipt has been there, Lordship. And seal is also
This
there.
is filed by Habib Ali Lordship.
Robert.
This is not filed by the Deputy Commissioner.
Not Deputy Commissioner.
I don't know how we have got this.
Okay.
So they
So-
had the knowledge in 8/10/2010, Lordship. And the certified copy, they have annexed, Lordship, as annexer 1, that is obtained in 2009 itself. That's page number 13, Lordship, of DI petition.
Yes. This is the photocopy of the certified copy.
Yes, Lordship. But it is DR annexer, Lordship.
Yes, any other submission?
Is 3 points, Lordship. One, they had the knowledge, Lordship, because in communication dated 7/10/2010 itself, they had got the information about pendency of the reference case. Lordship. Next, Lordship, they obtained a certified copy in 2009 itself, Lordship. And Lordship, this much only. Already we have obtained the enhanced amount. Lordship.
You have received the enhancement.
Yes. In
In fact, they
2000.
have received the enhanced amount. We have deposited it with a protest Lordship. And regarding this letter, Lordship, I don't know how he has received it. That is not marked to him. It is to government leader. And this beyond book and all, Lordship, there is no seal.
Seal is there, Lordship.
No, no. Amar seal নাই, IOC.
IOC র seal ও আছে।
মোক কোনো দেখা নাপায়। Seal নাই, seal-
If originally is called for your Lordship, seal will be accepted.
This, I don't know how they have got. It's very difficult.
Who is Habib Ali?
Habib Ali is the one of the landowners.
Claimant, yes, Lordship.
I don't know how he have received it.
Yes, government, anything?
All submission submitted by the appellant side, Lordship. As because of they have obtained a certified copy 31/2009. They have annexed. It is not annexed by other side, they have annexed. And in their statement, Lordship, they have stated that they have applied the fresh certified copy in 2022. But they have not annexed here the fresh certified copy. They have annexed here the certified copy which was obtained in 2009, Lordship. This is the important matter, Lordship. And other thing, Lordship, which was my learned friend has already been submitted. This is the Xerox copy. If this law court is permitted me, I will collect the original copy from the authority concerned, Lordship. Beyond book, Lordship.
Original copy of the,
Beyond book, Lordship. As because of here the IOC have received an acknowledgement signature also here in this copy also, Lordship.
yes, you produced,
Dated 8/10/2010, meaning
Produce.
thereby from 2010, they have the knowledge about this matter.
produce the original. When can you produce it?
Lordship.
Maybe 3 time, Lordship.
Okay.
I can collect.
Heard. Mr. What is your name?
M. Gogoi.
M. Gogoi, Learned Counsel for the applicant. Also heard Mr. N. Kolita, Learned Counsel for respondent number 1, as well as Mr. T. R. Gogoi,
Lordship. Respondent number 2.
Learned Government Counsel appearing for respondent number 2. This application under section 5 of the Limitation Act 1963 has been filed by the applicants, Messrs. Indian Oil Corporation Limited, within bracket Assam Oil Division, bracket close, Digboi Refinery, praying for this is a review application.
Not review, Lordship. Lordship will see the prayer, Lordship. In fact, in the first title, some discrepancy has occurred, Lordship. It's an appeal against LA appeal, Lordship.
Praying for condonation of delay of 4,792 days in preparing the connected land acquisition appeal, wherein the judgment dated 30/10/2008 passed by the Court of Learned Additional District Judge FTC number 3 in misreference case number 10/2002. Has been impugned. Learned Counsel for the applicant has submitted that in the aforesaid misreference case, the present appellant was not made a party by the reference case was filed by the Deputy Commissioner,
Reference case was filed
by the
as opposite party number 1, Lordship.
made as party. He submits that the present applicant / appellant came to know about the impugned judgment only on 4/4/2022, when the applicant received a letter dated 1/4/2022 from the Deputy Commissioner, Kamrup Metro, informing the pendency of money execution case number 7/2020. Stop. Learned Counsel for the petitioner, Learned Counsel for the applicant has further submitted that thereafter the applicant had applied for certified copy of the impugned judgment. However, the certified copy was not furnished to them, and the applicants in this regard also filed a complaint to the Court of Learned Additional District Judge number 2, Kamrup Metro.
Not number 2, Lordship.
Hmm?
Complaint is filed before the district judgment.
Before, not number 2, before the Learned District Judge Kamrup Metro. Learned Counsel for the petitioner, Learned Counsel for the applicant has submitted that the applicant again on 9/12/2022 applied afresh for the certified copy of the impugned judgment. You have received that
No.
second time.
Second time also we have not received. First time we have applied before the executing court. Executing court later on informed us that the original record is not with them.
Stop. On the other hand, learned counsel for respondent number 1 has countered the submissions made by learned counsel for the applicant by referring to a letter dated 7/10/2010, which is annexed as Annexure A in the Annexure A by the respondent number 1 in his affidavit in opposition, wherein the information regarding passing of the judgment in reference case. Which one is the reference case? Which one?
Many cases analogously.
No, which one is the relevant case? Information regarding 10/2002 by the Court of Learned Additional District Judge FTC number 3 was forwarded by the Additional Deputy Commissioner Kamrup Metro to the government pleader. He submits that copy of the aforesaid letter was also forwarded to the Area Manager IOC Assam Oil Division. He further submits that the extract copy of the peon book, which is annexed as Annexure 3 by Annexure B by the said respondent, also shows that Area Manager IOC Assam Oil Division Marketing Division have received the said letter on 8/10/2010. Therefore, he submits that the contentions raised by the learned counsel for the applicant that till 4/4/2022, the applicant was not aware about the impugned judgment is not believable. He further submits that in the meanwhile, the impugned judgment of the reference court has already been executed, and the respondent number 1 and other beneficiaries have received the enhanced amount of the compensation. Learned government advocate Mr. T.R. Gogoi also conforms to the submissions made by learned counsel for respondent number 1. He further submits that to remove any doubt regarding receipt of notice, regarding receipt of letter dated 7/10/2010 by the area manager IOC, he can produce the original peon book, extract of which has been annexed as Annexure B by the respondent number 1. Stop. Considering the submissions made by learned government counsel, the prayer is allowed. He is requested to produce the original peon book from which the extract, from which the Annexure B has been annexed by the respondent number one. Stop. Let this matter be listed again on.
Lordship may also record it that I have submitted that the document which they have annexed, the private party has annexed. How they have got the document, that has not been mentioned. This is the government record, Lordship.
Okay.
The public. No. How they have.
Though,
that
though,
is not mentioned.
though learned counsel for the applicant has raised a query regarding the fact as to how respondent number one, who is a private individual, got access to abstract of peon book, which is a government record, is not clear from the affidavit in opposition filed by the respondent number one. He paragraph to agot dibo. However, the prayer of London Government Council is allowed. He is requested to produce the original peon book before this court on the next date fix. Let this matter be listed again on 27th February, March.
In March.
March.
Because it will take time, I think. I don't know whether it will be. 10 March. Oh, like.
10th of
Next
March.
item also similar. 23 is similar.
There also peon book is there.
They have filed it, same thing, Lordship.
One more thing, Lordship, some other cases they filed for condonation of death, those were already rejected, Lordship, that I have annexed.
No, list this matter along with IA.
1014.
IA. This is item number 23, along with IA Civil 1014 on the next date fixed.
All right.
All right.
Item 24. Please, Your Lordship. Your Lords may recall this matter. On the last date of hearing, Your Lords has raised a query regarding the ownership of the land. That the person who owns the land was not being represented.
No, I don't remember anything.
Please, Your Lords. I'll just refresh your memory, Lords.
No,
Your Lords, this is a matter.
This is a interlocutory application.
Yes, Your Lords. IA 2022 of 25.
1078 of 24.
Your Lords, IA number 2022.
Item number? What is the item number? IA 2022 ase.
Yes, Your Lords.
But, and what is 1078?
Your Lords, I think that was a stay application, Your Lords, if I'm not stay application filed by them.
Left of court, Lordship, due to some personal difficulties, Lordship.
So you have to handle now. Why? Let us hear what the other side has to say.
Your Lords,
Okay.
may I submit?
2022.
Yes, Your Lords.
No, the counsel for the respondent is praying for.
I'm for 3, Your Lordship, Indian Bank. They are for Union of India. Basically, Union of India has preferred this appeal, the main case.
The RFA, Your Lords. This IA 2022 is filed by the liquidator of
The resolution professional liquidator
For selling that.
for
assigning the rights. Yes, Your Lords.
Okay.
Your Lords,
On
page
that
number
day,
50.
some respondent was not served the notice.
Rita Mandal, the owner of the land on which this company has development rights, Your Lord.
Yes, whether now
Your Lordship, Rita Mandal is the guarantor as well as the
Mortgager.
the borrower within the meaning of the SARFAESI Act. And
Your Lords, otherwise this is also recorded in the order. I'll show. Your Lords, kindly have.
no, whether now notice have been served on.
Yes, Your Lords, notice was served. I think someone also filed a wakalatnama as per my
Who is
instructions.
appearing? No one has
I
appeared.
am for 3 only.
Okay, now we can hear it.
Yes,
Okay. No, but there is an adjournment prayer.
Your Lords, I'm opposing
By
this
res-
because
Respondent number
Two
to the Union of India,
or one.
who has filed not respondent number two, but by the applicant, but by the appellant.
Is one, Your Lords. Two is the Guwahati construction.
One is opposing.
Yes, one is
in IAS, Your Lords.
like.
In IA, one is opposing. What is to be done?
Your Lords, I am opposing this because of this, because there is nothing in this matter as such, Your Lords. Only I am seeking for an assignment of the right. Anyways, I'll have to approach the NCLT. The only embargo which I am facing is the stay order which this court has passed, status quo order, because of which I am not able to assign it. I am just saying, let me assign it. The person who assigned it will come to my shoes and defend this suit, this RFA. And this will help me close the liquidation. Because of this, Indian Bank is not able to appropriate the money. We have a buyer who's ready to.
Bound period exercise, Your Lordship. And if we will keep on continuing, then we will not get the maximized value of the asset. And
Please,
here
sir.
is the case that the liquidator is not going to sell out the asset. It is just assignment. So, Your Lordship may kindly be.
Your Lordship has anyway heard the union on the last date of hearing at length. The only issue was whether this person who is the owner of the land was not served. We had served them. I'll show from the records that anyways this property is mortgaged. So she cannot anyways have any objection to this assignment of or granting of the prayer in my application.
And it is not going to change the nature and character of the pendency of RFA
No,
also.
no. Where is the service report?
Service report. We haven't received it.
Then on what basis you are saying?
Steps are already taken on December itself.
No, whether that would indicate that it has been served. You have taken steps, but unless we receive the report or track consignment,
Service awaited. Yes.
service is awaited. Though we remains.
I was informed that Mr. Sancheti has filed a wakalatnama. I am not sure, subject to correction from my local council.
The council has only filed it for the RFA actually, Lordship, not for the IEs.
Who has
To
filed
inform you.
wakalatnama?
Mr. Sancheti in the RFA. One S Sancheti.
Yes, Sanchit. He can appear in this case also.
That we do not know, Your Lordship.
Otherwise, we have to wait for service report. Because as on today, there is no indication regarding service of notice. Heard Mr. N. Goenka, learned counsel for the applicant. Also heard Mr.
M. Sharma for respondent number 3.
M. Sharma for respondent number 3. Also heard Miss A. Sharma appearing for respondent number 1, who submits that due to some personal difficulty, the learned counsel for respondent number 1/appellant had to leave the court, and therefore she prays for an adjournment. It appears that this interlocutory application has been filed by the official liquidator for the purpose of official liquidator of Messrs. Guwahati Construction Private Limited. Within bracket, corporate debtor for the purpose of assignment of assets of the corporate debtor as non-readily reliable assets. Within bracket, NRRA on as is where is basis with all litigation and encumbrances of the said assets. However, the matter could not be heard, could not be considered on last occasion as notice to respondent number 3, Srimati Rita Mandal, who is the owner
Yes.
of the land in question, was not served. Today, on perusal of the office note dated office note dated 3/1/2026, it appears that though the notices upon respondent number 3 have been issued by speed post as well as by usual mode. However, no office note as regards service of the said notice is there in the record. Stop. Registry is directed to ascertain the same and put up a appropriate note on the next date fixed. It is also directed to place the track consignment report of the notice sent to respondent number 3 by speed post on the before this court on the next date fix.
Your Lordship, one suggestion.
Yes.
Since in the RFA, Mr. Sancheti has already been appeared. So the copy of the IA may be allowed to be served on him so that the purpose will be sorted out, that he will be appeared on the next date by
Yeah.
taking the instructions.
Yes.
Because the Rajat Enclave address, I think the property has been sold out. The address which has been given.
Is it your submission also, Mr. Goenka?
Yes, Your Lords, I agree that if the party can be solved through council, Your Lords, I'll be highly obliged.
Learned counsel for the applicant as well as respondent number 3 has made a submission that since and a council has been engaged by the present respondent number 3 in the connected RFA, that is RFA 67/2024. The applicant in this case may be allowed to serve the notice of this interlocutory application along with the copy of this interlocutory application to the said engaged counsel so that he may take instructions from the respondent number 3 regarding appearing in this interlocutory application. The prayer is allowed. Let this matter be listed when.
A shorter date.
First week of February. 4th February.
Highly obliged, Lords. Highly obliged, Lords.
25.
Please, Your Lordship. Lordship, as per office note dated 5/1/26, no AD card or unserved notice is returned, my lord. I'll take steps through usual process, Lordship. Kindly release the matter after 3 weeks, my lord. In the meantime, I'll take steps through usual process, Lordship.
Heard Mr. M.M. Zaman, learned counsel for the applicant. This is a
Interlocutory application.
condonation
Yes,
bill.
Lord.
On perusal of the office note dated 5/1/2026, it appears that no AD card or unserved notice issued to this sole respondent have been received yet. Stop. The applicant is directed to take steps for issuance of notice upon the sole respondent by usual mode also within 7 days from the date of this order, returnable after 3 weeks. Returnable date at the returnable on 13th of February. The registry is also directed to place the track consignment report of the notice issued to sole respondent by speed post on the next date fixed, list accordingly.
Obliged, Lord.
Your Lordship, this IA is an application under Order 41 Rule 27. And on the last date, we were directed to 6 steps upon the respondents. However, Your Lordship, as per the office note dated 15/7/2025, both the respondents could not be served. An unserved notice has arrived for R1. However, for R2, there is no unserved notice.
What is to be done?
Your Lordship, what has happened in this case is none of the parties appeared in the delay condonation stage as well. For condoning the delay, we took steps by substituted manner via newspaper publication, and the delay was condoned, appeal was admitted, and stay was granted. Even in the appeal, we filed an affidavit for paper publication, and they did not appear. So since the last 2 to 3 days, Your Lordship, the court, honorable court was waiting for the LCR to be received so that the matter can be fixed for hearing. And now since the LCR is received, Your Lordship, this IA can also be taken up along with the main appeal at the time of the hearing. Your
What is this IA for?
Order 41 Rule 27 for adducing additional documents at the stage of appeal, Your Lordship.
The main appeal, in the main appeal, notice have been issued.
Notice was issued, Your Lordship, but they were not appearing, so affidavit via paper publication was published and service was
It was held to be due service.
Sure.
Okay.
And since the LCR has also been received,
Okay. Heard Ms. Abiani, learned counsel for the applicant. On perusal of the office note dated 15/7/2025, it appears that the notice issued to respondent number 1 has returned with postal endorsement within inverted comma, not known addressee, return to sender, inverted comma close. And as regards respondent number 2, no service report has been received yet. Stop. Learned counsel for the applicant submits that in the connected appeal MFA number 79/2022 also, the notice could not be served through usual mode as well as through postal mode, and it had the petition, the appellant was directed to take steps for issuance of notice by substituted mode, and only after publication of notice in the newspapers, this court held the notices to be duly served against the respondent number 1 and 2. She submits that in the connected appeal, the trial court records have already been received, and hence this interlocutory application under Order 41 Rule 27 may be taken up along with the hearing of main appeal. The prayer is allowed. List this matter along with connected MFA after 4 weeks.
much obliged, Your Lordship.
Please, Your Lordship. Your Lordship, as per order dated 8/1/2026, await service report, Lordship, upon respondent number 1, 2, 5, and 8.
What is to be done? Respondent number 1 to 5.
Respondent number 1 to 8.
Heard, Miss, what is your name?
Jerica.
B. Hajurika, learned counsel for the appellants. On perusal of office note dated 1/8/2026, it appears that the AD cards with signatures of the recipients on them issued to respondent number 3, 4, 6, and 7 have been received. And as regards other respondents, the same is awaited. Stop. It also appears that the service report of the notices issued to the respondent number 1 to 8 by usual mode is still awaited. Stop. On perusal of the AD cards received by the registry, it appears that same bears the signatures of the recipient, and hence the notice issued to respondent number 3, 4, 6, and 7 are held to be duly served. As regards the other respondents, the registry is directed to place the track consignment report of the notices sent to the said respondent by speed post. Stop. It also appears that the records of trial court and first appellate court have also been received. Please this matter after 4 weeks. Any 4 weeks.
Right. May I please allow? Service is complete. Complete. So, meter में काम for admission.
Heard Mr.
Sharma.
A. Sharma, learned counsel for the applicant. Also heard Mr.
W. Hawk.
W. Hawk, learned counsel for respondent number 1 and 2. Since the appearance of parties is complete in this case, let this matter be listed for admission hearing on 24, 12th of February.
Okay.
Just 31.
Wait, please. My lord, in this matter, my lord, I have an interim prayer also, my lord, that is pending in the last date, my lord. And we have taken steps upon the respondents, my lord. Service is awaited. The record has been received. The next date, my lord, before the lower court is fixed on 22nd, 22
January,
January, my lord.
what is the issue?
Issue is regarding, my lord.
Service is complete or not?
Service, my lord, we have taken steps, my lord, but service is awaited.
Okay.
Issue is that, my lord, the petitioner, my lord,
Which order you are impugning?
they have sought for amendment. Amendment was allowed. We are against that order.
Amendment of the
Amendment
probate
of the
application.
Probate petition, my lord. My lord, in brief, my lord, if I may summarize, my lord. What happened was that, my lord, one Nokul Chandra Borua, he had a particular plot of land.
No, but in such cases,
Yes.
do you also have any interim relief, interim prayer?
Yes.
What?
My lord, some protection may be given because next date probably, my lord,
What protection?
well, the matter may be stayed, my lord, till this matter is disposed of, my lord, because the issue is that trial has already commenced. Cross-examination of the PWs was pending. At that stage, they came up with this amendment prayer that was allowed. Now, Order 6, Rule 17 specifically says about due diligence of the party. But in this case, my lord, there was
not a single case of due diligence, rather, my lord, it is a case of negligence of the party itself, my lord. I may show that, my lord, if your lordship will kindly see the amendment prayer at page number 32. Page number 32, para number 3.
No, how the trial court heard?
My lord, because order 6 rule 17 says that generally all the amendment prayers are to be allowed. But if after trial commences, then the party must show that in spite of due diligence, they could not have brought these things on record earlier.
So is there any observation to this effect in the impugn order by the trial
The
court?
lordship will kindly see the trial court order, my lord. At page number 53. Para number 13 and para number 14. The issue which they want to amend is that, my lord, according to them, the test initially, my lord, in the petition, my lord, they simply said that the testator executed the will in favor of the petitioner, probate petitioner. Now, how it was executed, whether it was executed by affixing thumb impression or by signature, my lord, that was not mentioned. But the testator, my lord, wasn't practicing advocate.
But the trial court has reasoned its,
Yes, my lord, that's what we are challenging, my lord.
but that can it be challenged?
Yes, if your lordship will kindly see.
No,
order
can
6
it be challenged? Mayor erroneous, according to you, the order is erroneous.
Yes,
But trial court has given some reasons,
yes.
justified its reasons by citing some cases also.
LIC case, my lord.
So whether such an order, which according to you is only erroneous, can it goes into the jurisdiction, whether 227 can be invoked for rectifying mere erroneous error,
If I may submit, my lord, on
erroneous
this, my lord,
order
the
of the,
lordship will then examine, my lord, if I may submit, the issue.
no. We have to hear it only after service of notice. At least you have to show that notice has been duly served.
Notice, my lord, I do not know, but the last order office note says that, my lord, the service is awaited.
You have taken steps.
Yes, my lord.
We may direct them to by steps by speed post. So you have taken steps by speed post.
Yes.
We can verify whether notice has been served or not by calling for the postal track consignment.
But the lordship kindly give us an opportunity, my lord, to file a prayer seeking adjournment on the next date, my lord, 22nd. Otherwise, my lord, if the trial commences, my lord, the trial proceeds, then, my lord, probably, my lord, the question of prejudice will arise.
No, that prayer you can make before the trial court. There is no such bar. And it is for the trial court to consider. Why High Court should put its weight?
Yes, but my submission is that lordship may kindly dwell upon the interim prayer. If your lordship is not willing to consider the interim prayer today, at least, my lord, that liberty may be extended, my lord, that much.
Which liberty?
Seeking adjournment, my lord.
No, that liberty is always there. You can always seek adjournment
But
before.
if perhaps if it is rejected, my lord, then I will have no option, my lord. Then again, I will have
Then you
to-
come here.
Again, I have to file a separate petition, my lord.
No, what do you want?
So lordship may kindly hear on the interim prayer.
No, interim prayer in the such a nature of case can, in
Because,
my
my lord,
way,
initially on the first day, my lord, the honorable court was of the opinion that at least the record may be first examined, then the court will hear on the interim. Now, my lord, the record has already been received. So, already, my lord, around last month only we have taken steps.
now what do you want?
I'll leave it to lordship.
No, you have to seek something.
But I,
Interim prayer or adjournment.
but adjournment will not make any sense because the matter is fixed on 22nd. So, for
Okay, heard Mr. S. Das, learned counsel for the petitioner. On perusal of the office note dated 7/1/2026, it appears that the notice issued to the sole respondent by speed post has not yet returned. Stop. The registry is directed to place the track consignment report of the notice sent to the sole respondent by speed post within on the next date fix, that is it also appears that scanned copy of trial court records have been received. Learned counsel for the petitioner has submitted that in this CRP within bracket IO, the petitioner is aggrieved by the order of amendment by the impugn order by which amendment of the probate application was allowed even after commencement of trial, though the respondent / petitioner petitioner before the trial court had failed to show any due diligence on his part. Stop. Hence, he has stop. Learned counsel for the petitioner has submitted that under such facts and circumstances, he is praying for interim relief of stay of further proceeding of the probate title suit, as if the case proceeds with amendment which is impugned in this CRP taken on record, he will be highly. How many petitioners are there?
One petitioner. Madam.
He will be highly prejudiced. Stop. I have considered the submissions made by learned counsel for the petitioner. Considering the nature of grievance involved, grievance raised by the applicant in this CRPIO, this court is of considered opinion that any relief, be it final or interim in nature, may be considered only after due service of notice on the other side, that is sole respondent. Hence, the prayer for interim relief would be considered by this court only after due service of notice on the sole respondent. Stop. The petitioner is not precluded from approaching the trial court and praying for adjournment on the aforesaid ground. And if such an adjournment application is filed, same shall be decided by the trial court on its own merit. Let this matter be listed on 20th of February.
Perhaps an earlier date will be
I'll go to the 10th of
10
February.
February. Highly obliged. 42.
My lord, on reply to the queries of this honorable court, my lord, I do want to reply that the queries by filing an additional affidavit. Because of my lord, this court was asked on the which days the awarded amount was received. And as per information, as per instruction, only on the information given by the trial court engaged advocate that amount is satisfied and he was called to collect that.
You
amount
want to
from-
file an additional affidavit?
Yes.
Okay. Heard Mr. B. R. Das, learned counsel for the applicant who submits that who the applicant may be allowed to file an additional affidavit to bring on record the answers to the query posed by this court on earlier occasions. The prayer is allowed. Let this matter be listed on 11th February. Choose a date.
21 February.
21 February. Okay. 21 February.
33. My lord, here the matter is my lord. The petitioner and the respondent, they are husband and wife, and out of the my lord, marital wedlock, a female child was born on 4th of April 2023, now almost 3 years old. My lord. According to birth of the child.
Orders column. Why the matter has come up listed in orders column.
Here, my lord, the condemnation of delay, my lord. A guardianship application was filed before the family court at Dhuri seeking custody of the child, but the family court rejected the applications. Rejected my fear of custody, but at the same time granted the liberty to the
This
petitioner.
is delay condonation application. Okay. You are mother or father?
Father is a doctor and the mother, she is also a working lady. She is staying at Joy,
The
Meghalaya
child is with mother.
with mother. My lord.
How much delay has been caused?
My lord, the question of my lord, the welfare of the child. So, my lord,
You are opposing? Opposing or no? No. Yes or no? Be louder. Okay. Then we are allowing the condonation. Heard Mr. M.I. Islam. M.A. Islam. Learned counsel for the petitioner. Also heard Mr. G. Borgayari. Learned counsel for the sole respondent. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant for condoning the delay of how many days?
121 days.
121 days in preferring the connected first appeal against order, wherein the order dated 27/9/2024 passed by the which court?
Principal Judge Family Court Dhuri.
Passed by the Principal Judge Family Court Dhuri in FC Miss within bracket G case number 3/2024 has been impugned. Learned counsel for the applicant has submitted that the cause for delay in approaching this court for filing the connected appeal has been stated in paragraph number 3.
My lord, 2.
2 and
2, 3.
2 and 3 of the said application, and the said reasons may be regarded as sufficient cause which prevented the applicant from approaching this court within the prescribed period of limitation. Hence, he prays for condoning the aforesaid delay of 121 days. On the other hand, Mr. G. Borgari, learned counsel for the sole respondent, submits that considering the grounds stated by the petitioner in his application which has caused the delay, he does not have any objection if the said delay is condoned by this court. Stop. Considering the submissions made by learned counsel for the parties as well as grounds stated in paragraph number 2 and 3 of the instant interlocutory application to be sufficient ground which prevented the applicant from approaching this court within the prescribed period of limitation. The delay of 121 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected first appeal against order and list the same in the first week of February date. On 4th of February.
Hello. Not so good.
Item 36.
None has appeared for applicant on call. List this matter in the next week on a date to be fixed by registry.
Item 47.
Please, Lordship. 25 days delay, Lordship, please.
Notice.
Lordship, may condone, we are ready to deposit 50% also because unnecessary voter party will suffer, Lordship. The minimal delay of 25 days. Lordship, please, yes, I can take the step also.
No, you have not taken steps for issuance of notice.
So I am praying for allowing the I because
No.
only 25 days there.
Even if
Lordship.
now the claimant will get only 50%. If delay is not condoned, they will get 100%.
Lordship.
So without on their back, it may not be allowed. Notice has to go.
I'll take
Heard Mr. P.J. Burman, learned counsel for the applicant. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 20 February, list accordingly.
Obliged, Lord. Item 48. May I please, Lordship? We have got a respondent number 1.
What is this? Delay condonation.
Delay condonation, Lord.
Delay of 22 days.
You are opposing?
No, Lordship, we are not.
Heard Mr. P. Kolita, learned counsel for the applicant. Also heard Mr.
KK Dekha, Lordship. My name is not reflected. Today itself, we have filed a vocal document.
A.K. Deka appearing for only respondent number 1.
Lordship, claimant only.
And other respondents?
2 and 3, my lord, they are the owner and the driver, my lord. In fact, my lord, the notice was to be issued today, in fact, my lord. But they have got the knowledge that case is listed today. That is why they have filed the Wakalatnama perhaps.
They have filed, okay. Heard Mr. What is the name?
KK Dekha.
K.K. Deka appearing for respondent number 1. Where is the Wakalatnama?
Lordship, today we have filed, Lordship, this is the filing slip.
Okay. No, I am not disbelieving. As regards other respondents, you have to take steps.
My lord, basically, if he doesn't have any objection, delay may be condoned because the appeal is on the quantum, my lord.
Okay. Learned counsel for the petition applicant submits that the connected appeal has been filed by the insurance company, mainly challenging the quantum of compensation awarded to the claimant. And since the claimant has appeared in this interlocutory application, notice to the driver and the owner of the offending vehicle may be waived. Learned counsel for the respondent number 1 does not oppose the said prayer. Hence, the prayer is allowed. He also submits that he also does not oppose the prayer for condonation of delay, since the delay is only of 21 days. Stop. I have considered the submissions made by learned counsel for both the parties. considering their submissions as well as the reasons shown in the instant application which caused the delay in filing of the connected appeal by the insurance company to be sufficient cause, the delay of 21 days in filing the connected appeal is hereby condoned. Stop. The registry is directed to register the connected MEC appeal and list it for admission on 4th of February. This interlocutory application is accordingly disposed of.
Thank you much. 39.
My lord, is then IA under section 5 of limitation for condoning of delay of 1084 days, my lord.
Heard Mr. B.R. Das, learned counsel for the applicant. This application under section 5 of the Limitation Act has been filed by the applicants Rashwida Khatun and Umar Ali, praying for condonation of delay of 1084 days in filing the connected MAC appeal, in which they have impugned the order, they have impugned the judgment and award dated 21/6/2022, passed by the Motor Accident Claims Tribunal, Command North Lakhimpur in MAC case number 23/2018. Stop. Issue notice to the respondents. The applicants shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of
My
this order.
lord, respondent number 2345 is not required because of the trial court has awarded judgment against the respondent number 1. So on my own reads that respondent number 324 may be struck out.
No, you take steps at the first instance. If later on service there is any difficulty, then we may think about. Let this matter be listed on 21 February.
It is an application praying for substitution of respondent number 6 lordship. There is no delay lordship.
Heard Miss B. Hajurika, learned counsel for the petitioner. Also heard Mr.
DJ Mehdi on behalf of
DJ Mehdi, learned counsel appearing for the respondents. This application under Order 22 Rule 4 of the Code of Civil Procedure 1908 has been filed by the applicants praying for substitution of the legal heirs of respondent number 6 in the connected regular second appeal number 92/2024. The respondent number 6 has expired on 1/9/2025, and it is submitted at bar that the instant substitution application has been filed within the period of limitation. Stop. Learned counsel for the other respondents does not oppose the prayer for substitution of the legal heirs of respondent number 6. Accordingly, this substitution petition is allowed. The name of Srimati Sujita Kanu, number 2 Prachi Kanu, number 3 Divyanshi Kanu, and Rohi Kanu may be substituted as respondent number 6.1, 6.2, 6.3, and 6.4 in place of the deceased respondent Shri Tapan Kanu. The appellant shall file an amended cause title and memo of appeal in the connected regular second appeal within 2 weeks from the date of this order. This interlocutory application is accordingly disposed of.
42.
Your Lordship, here we have filed 3 IAs. Condonation, substitution, and Lordship setting aside abatement and Lordship.
Lordship, in this case, Lordship, delay, Lordship, 1,571 days, Lordship. I will file written objection.
Heard Miss B. Hajurika, learned counsel for the applicant in abatement application, that is, I condonation condonation application, I 40. Only orders will be passed in that case only. Also, Miss
P. Adhikari, on
P.
behalf of
Adhikari, appearing on behalf of G.Uddin, learned counsel for the respondent, who submits that considering the huge delay involved in this case, the respondents intend to file a written objection against the prayer for condonation of delay in filing the application for setting aside abatement on death of who died? On death of respondent number 1. The prayer is allowed. Let this matter be listed. 12th of February.
My lord, today was fixed for submission of affidavit on paper public. So my lord, today I have filed that original affidavit copy along with paper part. So I think
No, this you have to file in the filing section.
I have filed already, my lord. In filing section, I have filed.
It
to
has
show
not
the court I have just written the copy.
It has not been tagged.
My lord,
The affidavit has, whether it has been tagged with the record.
no,
or
no.
Not,
They itself filed.
okay. We'll fix a short date.
5th February.
Okay. Heard Mr. B. R. Das, learned counsel for the appellant, who submits that in pursuant to the directions of this court, he has filed an affidavit of compliance regarding publication of notice in the newspapers as directed by this court. However, the said affidavit is not tagged with the record. From the registry is directed to tag the aforesaid affidavit and list this matter again on 4th or 5th of February. The remaining matter left over.
My lord, in item number 43, a date may be given on 11th of February.
Item number 43, 11th of February.
My lord, item number 52, my lord, it may be fixed on 5th February. Because
52 5th.
Lordship, can 43, can it be after 11th, May?
My lord,
You-
matter,
43.
this honorable court remanded back the matter to the.
That's one, and only
First
after
appeal
11th, May.
for SRT.
12th,
May.
12th,
12th is a motion day,
13th,
13th, my lord.
13th, 13th.
Oblige.
May I pray lordship to fix the item number 51 tomorrow, lordship. So learner trial court fix original suit and day after tomorrow. That is why the matter is fixed today, lordship.
Tomorrow,
Interim-
tomorrow para যাবে না?
Interim prayer is there, matter is very urgent.
Hearing matter,
No, lord, order, maybe fix in order column,
50,
51, lordship. The original suit is fixed day after tomorrow. That is why this matter is.
what
fixed.
is the stage?
At the stage of evidence, lordship. So learned trial court interfere with the issue of another case by allowing an application. Whereas that issue is connected with.
No, what is
another-
the urgency?
Urgency, no, a stay prayer is there, lordship. Interim prayer.
Okay.
Kindly fix tomorrow, Lordship.
tomorrow at 2.
Fine.
Item number 55, Lordship. We need to fix a date, Lordship, because here we Lordship, actually. 1.5 has been extra. They have supplied.
Lordship, they have supplied the details today, Lordship. We'll file the
55, 13 February.
we'll file the substitution.
Yes, we are not passing any order. You can file substitution petition. There is no bar.
Item 49 and 50, we have filed our dusty affidavit, my lord. And even the other side has filed their wakalat nama.
We filed the wakalat number today.
So maybe fit for admission with the TCL.
49 and 50. Heard Mr. G.P. Learned counsel for the petitioner. Also heard Mr.
A. Chaudhary.
A. Chaudhary appearing for the sole respondent.
Yes, in item number 49.
Sole respondent in item number 49. In item number 50. In item number 50, Ms. A. Talukdar for all the respondent. These are connected matters or these are connected, or let this matter be listed for admission hearing on 11th of February.